With the permissions of my lord, so, my lord, there is one matter a bit towards this stage. My lord, we don't want to continue with the litigation. My lord, we want to withdraw our petition, my lord. Can it be? No. Please, my lord.
Lordship, with your permission. Lordship, in execution petition 41 of 23, we have filed an application for release of amount. We had filed.
Please, Lordship. In this matter, but directed to have the instruction with respect to what had happened to the proceedings which were against the other person's lordship. They filed a revision petition, lordship, which was not maintainable, and that has been dismissed before the authority, authority, but that being not maintainable, lordship. That order just like.
But how do you explain the delay?
Since it is a case against a dead person, lordship.
You see, it is not a per se judicial proceeding.
But at the same time, if what was direction in my in the favor of the deceased husband, lordship, that he will be, he is not seeking that he will be added as a member, lordship. He is only seeking that he was member. His truck was already been plying, but due to the accident, lordship, his truck was subsequently was not played.
Read page 18 of the paper.
Please, lordship. Let me have please, lordship. Beginning, lordship. In fact, if the Malad may just have the operative part of the orders, the learned authority below is on the basis of some judgment of Honorable High Court and some high power committee, lordship. But those are the matters where they were seeking their membership, lordship. It is not the case that I'm not the member. If Malad may have the orders of the trial which was in my favor, lordship, it has been held that though I am the member, but for certain reason, lordship. Please, lordship.
Reply in 6 Yes, Surinder.
In this case, this petitioner, he was admitted in this BSc Medical Laboratory Science course in this point number 4 issue. And after the completion of the degree course, he was to undergo that 4 months professional. For that, you should write an exit P1. A request was made by the institution to this respondent number 3 college that kindly impart him 4 months training, which is a part of that degree course. In person to this, filed an exit P2 page 25. That permission was accorded with the prior approval of the respondent number 2. This permission was accorded by respondent number 3. There is a note appended on this at the bottom. Candidates, page 25, candidates undergoing internship less than 6 months will not be eligible for registration with the USP Paramedical Council, as clarified via email under reference. So, this is a controversy that initially the request was made by the institution for imparting him 4 months professional training. But as per the requirement of this Paramedical Council, I had to go this 6 months training. Thereafter, repeated communications were there. Wide and exit P6, page 29 of Milo's paper book. The matter was taken up by the respondent number 3 with the respondent number 2, that now a request has come from the institution to impart 6 months training to the student concerned. However, initially this request of the petitioner, rather the respondent number 3 institution was dealt with by the respondent number 2, wide and exit P7, page 33. There certain observations were made that the institution may kindly be asked to furnish the memorandum of understanding with the medical college, and that document was supplied by the institution to the respondent number 3, which was forwarded by respondent number 3 to respondent number 2, wide annexure.
Issue is that in terms of annexure P12,
please,
this institution में आपको बोल रहे हैं जाने को, it has certain issues.
Please.
So then, what is the role of the High Court?
They say that
it's not going to validate the infirmities in the institution. You may request them to depute you to some other institution for this 6 months training.
So far as this annexure P12 is concerned, Mileage may kindly page 45. In this regard, it is to submit that the permission for internship may be
You cannot espouse the cause of the CT Institute of Pharmaceuticals.
as an individual, as a student.
Neither as an individual, nor in any other capacity.
Please,
Now you are a student.
please,
आपका सिर्फ इतना concern है that for the purposes of being enrolled with the paramedical council,
please,
you have to undergo 6 months internship.
Please.
6 months internship.
ਹਾਂਜੀ.
Do internship somewhere else.
So far as
Internship
please,
in an institution for which there is no issue as to whether it fulfills the necessary criteria, etc. or not. आप कहीं और जाओ.
so far as this next P12 is concerned, from the plain reading of this, it appears that this is with regard to this permission cannot be granted because after scrutinizing the MOU of CT Institute, Science of Pharmaceuticals, so and so, so and so.
Issue is very simple.
Please,
Let us take a case that there is a young lawyer
please,
who comes and says that it's an internship करनी.
please,
Authorized person says that okay, do internship with X lawyer.
please,
Bar counsel says that sir, internship with X lawyer is not
please,
feasible for the reason that we have a doubt with regard to
please,
the veracity of the certificate on the strength of which he is practicing.
please.
How can the student come to the High Court and say that this observation of the bar counsel vis-a-vis the lawyer is bad? आप तो ये बोल सकते हैं सर मैंने क्या लेना देना मेरे को कहीं और भेज दो.
मेरा वही है जी, because I have
Approach them. Approach them.
I have already undergone the 6.
ठीक है Mr. Additional AGV.
Do that.
कहीं और भेज दो.
And actually P9 में
मैंने क्या लेना देना.
just for a
You
second.
should be concerned with your relief.
Yes, Your Lordship.
तो आपको
I
when the government is benevolent enough.
हाँ जी.
बताओ कहीं भी.
Actually मैं कर चुका हूँ जी 6 महीने की ट्रेनिंग from this
Catch.
respondent number 3 college.
वो नहीं है सर.
I am not asking that general permission may be accorded. I as a student, I as Anupam Chandel, since I have already undergone 6 months internship.
Sorry. You see, question is very simple.
Please.
Simply file a suit for damages against the person who has sent you to an unrecognized, unaffiliated, etc., etc. High Court is not going to give legitimacy to your internship.
Issue is not with regard to respondent number 3 college from where I have already undergone the internship. Issue is of this is
6 महीने 4 महीने.
हाँ जी 6 महीने 4 महीने का. And the second issue which arises out of this A12 is P12 is that the institute from where I have studied, I have done this degree course, is not affiliated and associated with some hospital in the state of Punjab. So far as internship part is concerned, I have already undergone.
No problem.
For 6 months.
एक से एक और एक सर नंबर 2 के लिए कौन आएगा?
State.
What is the status of this council? It is a statutory council.
Yes, Your Lord.
उनको notice करो. Mr. AG, you will accept for 1 and 3, sir. एक और 3 के लिए पुष्पिंदर. 2 और 4 को notice return for dash steps within 1.
Please. Any date after 4 weeks.
Like you did this. Yes, Kalyan sir.
In this matter, my lord, the road was constructed in the year 2011-12, my lord. And at the time when road was construction, objection.
AG accept.
My lord.
8 weeks.
Great.
SLP was filed in Supreme Court. After some days, this number also.
वो वाला केस है आपका?
हाँ जी वही वाला है. वैसे मार रहे जी बहुत ही है. 10 से लड़ रहे.
After vacations, we don't know what the rosters will be, sir. So wait for some.
थोड़ा जल्दी लगा लें लॉर्डशिप.
Sir, we don't know what the rosters will be. We'll keep it after vacation. No, but you see, if the SLP has not been listed before the Honorable Supreme
ये तो 3 बार चली गई जी, 3 बार डिसमिस हो गया.
Please, is it in our control or control of the other party as to when the Honorable Supreme Court will? So please do not make unnecessary. This case is not so special that it has to be heard by the High Court in a manner different to the other 100 cases listed. When is the Honorable Supreme Court reopening?
30 July.
उसके बाद लग सकता है.
एक सप्ताह उसके बाद.
लॉर्डशिप वेकेशन जज तो बैठते जी, लास्ट टाइम ये बात हुई जी. इमीडिएट आफ्टर वेकेशन रख लेंगे.
Learned senior counsel appearing for the respondent bank informs the court that the special petition has not yet been listed. Supreme Court. Taking into consideration the fact that the Honorable Supreme Court is presently closed for summer vacations, the case is ordered to be listed on 21st of July. in the
जून में रख लें लॉर्डशिप.
when the
वेकेशन तो वेकेशन जज के पास में
can I force them
ना, फोर्स तो नहीं,
indirectly?
तो तब रख लेंगे.
Can the High Court indirectly through him make any observation that the Honorable Supreme Court should take up a
No, मैं ये नहीं बोल रहा लॉर्डशिप.
decision of the Honorable Supreme Court?
Lordship, I am not saying so.
Partial court work.
अगर मैं ऐसा ऑर्डर पढ़ता हूँ, indirectly it will be construed as if the High Court is making any observation to the Honorable Apex Court. वो थोड़ी भी मैं करूँगा सर.
वो last time.
सत्यप्रकाश.
Please, Vinay. The state is directed to file some compliance report.
Order क्या है?
The last three. Page 11.
Yes.
We both were under the impression that it is listed on Friday. So my lord may kindly take it on
Friday बोलो. Surya Chauhan, yes, Surya.
short possible option there.
Lordship, this matter was kept for today on account of whether Section 5 of Limitation Act will apply to appeals under Section 93 of the Cooperative Societies Act. Lordship, passed by the Honorable Coordinate Bench, Lordship, 19th of May, Lordship. Lordship may have para 2, Lordship. The question of law posed is whether the provision of Section 5 of the Limitation Act apply to an appeal under Section 93 of the HP Cooperative Societies Act 1968. Then Lordship may kindly have para 11, page 9, Lordship. Provisions of Section 49 and 93 have been quoted. Thereafter, Lordship, para 11, a perusal of Section 49 of the Act would make it crystal clear that provisions of Limitation Act have been excluded in its applicability. Sections 69, 73, and 88 of the Act of 1968, meaning thereby that provisions of the Limitation Act, excluding the aforesaid sections, would be applicable to all other provisions of the Act of 1968, including the appeals and reviews filed therein.
There are other judgments also.
But Lordship, in this matter, the considering the judgment of the Supreme Court also, Lordship.
Correction. जहाँ तक मेरी knowledge है, there are other judgments also of the Honorable Court, maybe Honorable Coordinate Bench or Honorable Division Bench. To the contrary, you will have to.
And Lordship, may give me some more time, Lordship, because I found it.
Don't worry, I am not. You have done your job. You have done your job as the counsel for the petitioner. Now I am requesting you to do your job as an officer of the court. ठीक है? Monday को मेरे को वो judgment भी दिखाओ इसी issue पे जो और benches. Let us assume that other honorable coordinate benches have given similar judgments, then it is one thing. If there is a conflict, then it is one thing. If there are judgments of the honorable division bench to the contrary, then it is one thing. Please,
Okay. Great Lordship.
Request to counsel for the petition. List one. I'll simply. Okay. ये रख लो.
List one.
Encroachment, proceeding was initiated against me, and
last order कहाँ पे है?
Yes, sir. Last, first order, Annex P3 is the assistant grade 1, and that is at page 33. I have taken the question of title. They have denied.
Which is the last order?
Last order is Annex P5. P6 that is page at page on body 50 47.
How much is the encroachment?
111 square meter.
कहाँ पे?
Mangwai Mandi.
What is your defense?
I have taken the plea that if my lord Annex P1, please make kindly. Running page 12. In possession column, Raja Joginder Sen was recorded as possession. What happened during the settlement?
Yes, Annex P2, you'll see. And in specific at page 22, you'll see.
कल क्या हुआ? कल भी तो
No, yes, you'll see. Same notice किए हैं, you'll see. Yes. Yes.
For the submission of this code.
He has taken two stands.
Yes.
Gupta ji, मैंने
Don't worry,
Yes,
don't
yes.
worry.
हाँ जी, लड़से मेरी stay की भी है इसमें जी।
मैं भी नहीं दिया।
नहीं लड़से इस continue है 12 तक सी,
same order.
12 तक continue। Okay.
Yes, sir. Prashant Sharma.
Please, my lords.
Yes, please.
Your Lordship, I am before your Lordship on account of the inaction on the part of the authorities with regard to declaring my building unsafe for human habitation. I'll just take your Lordship to few documents. One is at page 76, Mila. Page 76. Here it is an approval by the Town and Country Planning to me for raising my house, and I raised in accordance with the guidelines.
Mr. Jeevan,
Yeah.
which is the impugned order? Which is
I'll just go through. At page 155.
in the relief clause? What do you want to be? What do you want to be quashed? What do you क्या है?
मैं बता रहा हूँ, एक 155 पे देखें.
Yes.
There is a letter from the SDM to the commissioner. उपरोक्त विषय पर सुषमा शर्मा, संदीप शर्मा, जगन विला, सूर्य किरण कॉलोनी, बावरा, चंबा घाट, सोलन से प्राप्त शिकायत पत्र के अनुसार श्रीमती सुनीता ठाकुर, प्रिंसिपल शेड्स कॉलेज, चंबा घाट द्वारा लगभग 30 फीट की सीधी पहाड़ी काटने के लिए जेसीबी मशीन के निरंतर उपयोग से निर्माण किया गया था। वह कटिंग करके एक डंगे का निर्माण किया गया। श्रीमती सुनीता ठाकुर द्वारा किए गए निर्माण कार्य डंगे की जगह बैठने के कारण शिकायतकर्ता संदीप शर्मा के मकान की नींव में दरारें आ गईं और मकान के नीचे की ओर भी दरारें आ गईं। शिकायतकर्ता द्वारा पूर्व में भी प्राइवेट रिस्पॉन्डेंट।
What is the role of this?
Yes, my lord. She without the approval of the Town and Country Planning started raising construction on a contiguous.
Civil issue, go to the civil court. It is a pure and simple civil issue.
My lord, what I'm submitting, my lord. Now, what is happening?
Whatever.
I'm only for the limited purpose before your lordship.
Go to the civil court.
I'm only for the limited
You have to
purpose
establish everything before this.
with your lordship. अतः आपको भेजकर अनुरोध है कि शिकायतकर्ता के भवन और साइट का तत्काल निरीक्षण करने के लिए एक तकनीकी टीम नियुक्त की जाए। I am Lord, what I am submitting now. Municipal corporation says that aware that this is unfit, you demolish it. Now, my lord, what I am fearing, Lord, I am ready to bear the expenses under the monitoring of the municipal corporation under a technical committee, because there could be a collateral damage to the contiguous house. I have suffered this damage because I will be recovering everything from her, whatever. But as far as the damaged part is concerned, because I have vacated the house, now I am just requesting at least appoint some committee under your monitoring. I will demolish it. I will bear the expenses.
Approach the commissioner.
Lord, I have approached. What he is saying.
Direct him to take a call. There is
Lord, that will be because what he is saying.
Who is appearing for the commissioner? Where is that letter, Mr. Jeevan?
My lord, that is the letter which I was saying at page 155, 12th of March 2025.
No, where is your request to the corporate?
My lord, yes, my lord. Then there now, my lord, what is happening at page 164? When this letter went to the commissioner, at page 164, what commissioner says? This is with reference to your subject cited above. In this context, it is submitted that.
You see, you cannot treat the High Court as a post.
Lord, I cannot.
Just listen. Just request के साथ आप High Court में आए हैं.
जी.
Have you approached the authority?
161
Asking the commissioner to do this, and because he's not doing that.
Yes, my lord.
बताइए.
P28, 161.
161. There, I have addressed it to the Deputy Commissioner, come Chairman, District Disaster Management Authority, District Solan.
You approach the commissioner.
Thereafter, my lord, then there is a letter from the Deputy Commissioner to the Municipal Commissioner. This is with reference to office letter dated itna of such and such. In this regard, you are requested to visit the site at the earliest and submit the action taken report in this office within 1 week from the date of the issue of the communication. Now, what he says, this is with as to your subject cited in this context, it is submitted that the provisions of 258
High Court cannot be used as a tool to create evidence in the course of your
Lord,
litigation with the private
with
cannot become a party to the litigation.
with due deference.
Now what you want is that the High Court should appoint someone, ठीक है, ताकि आपके पास एक सबूत आ जाए और आप फिर जब सिविल सूट फाइल करेंगे रिकवरी एटसेट्रा का अगेंस्ट द प्राइवेट रिस्पोंडेंट, तो you will use it as a tool.
Lord,
now no one can object to it because it has been done.
No. Lord, I am
become a party to.
Lord, I am only with a limited prayer, Lord, because now if your Lordship have the look,
is remiss in its statutory duty.
Yes, Lord. What I'm submitting before your Lordship.
What is the statutory provision?
What I'm submitting, Lord, it is in a very peculiar circumstances. I'm before your Lordship. I have suffered damage. I'm not here for creating any, because it is a report of the revenue authorities and the municipal corporation itself that it is because of the acts and conduct of the contiguous landowner which has caused this damage. Things would be proved in a civil court. What I'm submitting, Lord, now I have vacated this house.
This is not what 226 is meant for.
Lord, what I'm submitting, Lord, I want to demolish this house. Lord, what I'm submitting.
Approach under Article 226 for this particular.
Lord, I'm just praying before your Lordship that there be direction to the municipal corporation at least to monitor the demolition.
I will not do that. You want the High Court to become a tool?
No, Lord.
No, sorry, I'll not do that. Under what law?
They say.
Mr. Jivan, मैंने पहले भी आपको एक query raise की थी.
जी.
Which is the statutory authority which is remiss in the performance of its statutory function?
It is.
You can invoke the jurisdiction of the High Court if there is a violation of fundamental right or legal right.
My Lord, what I'm submitting.
That in such circumstance, it is an onerous duty of the corporation.
Yes, Lord.
Supervise the demolition under this particular provision of the
Lord.
Municipal Corporation Act, and the commissioner is not doing that.
Lord, he under 258. No person shall, without the written permission of the commissioner or otherwise than in conformity with the conditions, if any, of such permission, use or permit to be used in such habitation.
It says that if the structure of a person becomes dangerous because of the acts of omission of a third party, then demolition of that particular structure will be supervised by the commissioner.
May I submit, my Lord? Submit. They are saying you demolish it. I'm ready to demolish it, my Lord, but I'm submitting, my Lord. There could be collateral damage of the houses there, Lord. Lord,
उसमें 26/9 में देखो जरा क्या हो सकता है. 26/9 को एक्सप्लोर करो सर. प्लीज एक्सप्लोर 26/9. 26/9 का मतलब थोड़ी डिमार्केशन करवा दी.
नहीं जी, मैं सिर्फ इतना सा बोल रहा हूँ जी. Yes, Lord. Appointment of a local commissioner.
Why? For what reasons?
My Lord, to see.
There are so many reasons.
Yes, my Lord. There's so many reasons.
So 26/9.
I'm aware, my Lord.
नहीं मैं करूँगा.
मैं वो भी नहीं बोल रहा जी.
कर लो चुपचाप से सिविल कोर्ट के लिए rather than taking a dismissal from the High Court.
इसको फिर रख लेंगे. Instructions. I'll seek instructions.
Having heard the senior counsel for the petitioner, this court is of the considered view that the relief paid for cannot be granted under Article 226. On the request of the senior, list tomorrow to enable him. Yes, Praveen Chauhan.
Yes, Your Lordship.
Yes, ma'am.
Your Lordship, challenges to the impugn order P8, which is the recovery notice issued by respondent number 3, Your Lordship. The issue involved, Your Lordship, here is it was a contract matter. Contract was rescinded. I approached the internal dispute redressal committee under the contracts, Your Lordship. The matter is pending before the internal committee, and pending that decision, they have issued me the recovery notice, Your Lordship. So my submission is this.
What is the agreement?
Please, Your Lordship. Your Lordship, as per clause 50, as per clause 52, that contract was terminated.
Clause 52.
Please, Your Lordship. That's page 68, Your Lordship.
68.
Yes, sir. Termination of the contract, Your Lordship.
Is there any arbitration clause in the?
No, Your Lordship, they had an internal dispute redressal.
Where is that?
That is at page, Your Lordship, 58, clause 24.
Please read it. If any dispute or difference.
Please, Your Lordship.
Just give me 1 minute. Okay, when did you raise the issue with the dispute redressal system?
Please, Your Lordship. In fact, I raised the first dispute in 2023, Your Lordship. They did not form the committee. They did not take my appeal. I came for the pre-litigation mediation, Your Lordship, and they suffered a statement that they are going to form the committee. And the first notice I received from them was on 8th October 2024, Your Lordship. Thereafter, I preferred my appeal before the committee on 27th of December, Your Lordship. That is P7.
When was the contract rescinded?
Contract was rescinded, Your Lordship, on 17/4/2023, Your Lordship.
17/4/2020.
Please, Your Lordship. And I came for the pre-litigation mediation on 26th of 4/24 because during that period they have not formed the committee, neither have internally decided my appeal, Your Lordship.
Okay, then what happened?
So I came for a pre-litigation mediation and they suffered a statement that they're going to form the committee.
Is that order?
Please, Your Lordship, kindly see C2 is the statement which they have suffered.
Page.
Page 104 is the statement before the pre-litigation mediation, Your Lordship. Page 104.
Till date, have they formed any committee or not?
They formed the committee, Your Lordship. I received a notice from the committee in October 2024. I appeared before the committee and accordingly I filed my appeal also, Your Lordship, in December 2024. The meetings was held by the committee in January 2024-25, but till date no order has been passed, Your Lordship. And in the meantime, in April, I have received this notice for recovery, Your Lordship.
Ma'am, just 1 minute. You see, now the Honorable Supreme Court has very clearly said that as far as arbitrations are concerned,
Please,
a person who is interested
Your Lordship.
cannot be an arbitrator.
Please, Your Lordship.
So officers of the government departments, etc.,
Yes, sir.
which are involved in arbitration proceedings can't now be the arbitrators.
Your Lordship, there is no arbitration clause. Please, I bow, Your Lordship.
So they can't be arbitrators now.
Please, Your Lordship.
What cannot be done directly? Can it be allowed to be done indirectly?
No, Your Lordship.
Because your dispute redressal system
Please, Your
also constitutes of the same persons.
Please, Your Lordship.
So will it not indirectly be?
That is the special secretary PWD. He is not part of the contract, Your Lordship.
He is not part of the.
He is not part of the contract, Your Lordship.
No, you see, at the end of the day,
He is one of the functionaries.
no, he is not one of the functionary. He is the principal functionary as far as Public Works Department is.
Please, Your Lordship.
So indirectly, he is becoming a judge in his own cause.
Please, Your Lordship. But he has not passed the order. My concern here is.
Issue.
My concern here is only.
As to whether ये जो dispute redressal system है,
Yes, sir.
will be sustainable in law or not.
Oh, that's true, Your Lordship. I bow. I agree, Your Lordship. But this issue pertains to. In the meantime, I am praying for the stay of recovery, Your Lordship. P8.
हाँ? सबके लिए लेंगे आप reply in 6 weeks please thereafter. तो miscellaneous में करना notice in about other orders. Recoveries in terms of impugned annexure 23/4/2020. नहीं ऐसे लिखना miscellaneous में करना notice in about terms. till the next date of hearing, no coercive action shall be taken against the petitioner pursuant to annexure PA dated 23/4/2000.
Oblige, Your Lordship.
Please have it.
Gratefully, Your Lordship.
Yes, please. Abhilasha. Devendra Kumar Sharma.
Your Lordship, the bank account of the petitioner has been freezed, Your Lordship, from Maharashtra, Kolhapur, Your Lordship, under the complaints, some complaint, Your Lordship, that originated in, Your Lordship, acknowledgement number. But the applicant has nothing to do with the complaint, Your Lordship.
How are the writ petitions amended?
Lordship, as the
These are, you approach under the cyber crime jo bhi hai.
Lordship, I approached to all the authorities that I can, Your Lordship, but they are,
So some other, kitna paisa us account?
Lordship, 11 lakh rupees, Lordship, and on just account of 900 rupees, Lordship.
What's the allegation against you?
Nothing, Lordship. I'm not even in the allegation, Lordship. I'm just in the acknowledgement number.
Which is the order in terms. Okay, notice kar dete hain. Let us see what they have to say. Notice confined to respondents 1 to 3. Reply within 3 weeks. List on that.
Lordship, kindly to respond number 4 as Lordship, as the accessory party, Lordship, as.
Let us see what they have to say. Huh?
Please, Lordship.
Agar inke jawab ke baad zarorat padegi, then we'll issue notice.
Please, Lordship.
At this stage, Arush.
Please, my lord. Lordship, in this matter, the petitioner is aggrieved by the inaction of the respondents. The matter pertains to Lordship, upgradation of Katta Bhatti to with IBR, Lordship. My lord, in the identical matter, Lordship, please to pass the order with an excerpt P5. So direction may be given to decide my representation. Please, my lord.
Confined to notice. Learned AG accepts notice on behalf of the respondent. At this stage, as I recall, by way of this writ petition, respect for the following. At this stage, learned counsel for the petitioner submits that interest of justice will be served in case the respondents are directed to decide the representation that has been filed by the petitioner. Annexure
P3, Lordship.
within some reasonable time. Full stop. In the light of the prayer so made by the without adverting to the merits of the case, this petition is disposed of with the direction that let the representation of the petitioner be decided by the competent authority within 4 weeks from today by adhering to the principles of natural justice. Yes, this first motion.
This matter is also the same, Lordship. Same and excerpt. Same and excerpt.
First motion. Yes, Mr.
Alert may have order dated 10th of December 2024 month.
28th of
10th of December 2024 month. Alert, why this order? The learned council 103 were directed to have instruction with respect to the formation of district level committees. Because what was our case? Our case was but we were there, we were elected to it, and they appointed an ad hoc committee, and since then they are working on this head ad hoc committee. And we are the duly elected committee, as per our constitution and my law. And in this,
how do you say the petition has lost its efficacy?
Look, kindly have 11th June 2018 order.
11th of June.
Yes, Lordship. In fact, will not be filed the petition on the premise that.
Just 1 minute. Just 1 minute.
Yes, in para 5 will be important.
18.
Yes, Lordship. 11th June 2018. And para 5 would be relevant. The Honorable Division Bench had.
As observed earlier.
Yes, Lordship. Had appointed the Lord committee, duly appointed to the court, and they went there, they selected, thereafter this order was passed.
No, so this is a decided case.
Yes, it was not decided. Honorable court said, Honorable court said that if he allows, if you kindly have.
Wait, just 1 minute. Just 1 minute. Petition is disposed of, leaving parties to be. This is
exactly. Honorable Division Bench also committed this under review.
But fair enough.
That was not for this purpose, that review was allowed.
Okay, no problem.
And after that review, this petition
Okay,
appeared.
okay,
Then
no,
it
no.
was not taken up for
many years. I filed this application.
What is the state of the respondents with regard to the grievance of the petitioner? That till date there is an ad hoc.
No, now there is no ad hoc committee.
Election कब कराया आपने?
So then I will file a proper affidavit, showing my.
What do you say?
I say no election has taken. Who should have
Okay. इसमें लिखना आपने, इसमें लिखना the senior counsel for the petitioner submits that the petition has not lost its efficacy for the reason that till date the grievance of the petitioner has not been addressed, as regular elections have not been held till date to elect a district level cricket association for the district of Lawrence. Learned counsel appearing for respondent number 3 prays that he may be granted 2 weeks time to have instruction in this regard. Based on that, in case elections for the constitution of the district level cricket association have not been held till date, then learned counsel for the response shall also have instructions as to how soon needful will be done by the response. अब कराओ election का कोई पंगा डाला हुआ है?
Although as per my information, they have conducted the election, but I will file affidavit.
2 हफ्ते बाद actual date, छुट्टी के बाद.
Committee. May I make well and I made a for withdrawal. The only thing is that in view of the amicable settlement, we are withdrawing.
वो लिख देंगे.
We are withdrawing, and if liberty.
वो नहीं होगा, वो liberty नहीं होगी.
अगर वो settlement from.
न वो नहीं है ना, वो नहीं होगा. ये हो जाएगा कि in the light of the उसमें ऐसे करना.
हमें तो लिख के दी चिट्ठी में तो उसकी वजह से बोल रहा हूँ.
Learned उसमें लिख देना learned counsel for the petitioner जो order है ना सर, submits that in the light of subsequent developments as the matter now stands amicably settled between the parties, the petitioner be allowed to withdraw the petition at this stage. ठीक हो गया ना? Liberty नहीं सर.
अगर वो लिख भी देंगे वैसे
नहीं सर नहीं.
उससे क्या होगा कि जिन्होंने सेटलमेंट किया है
at this stage आ गया ना? At this stage is allowed to withdraw the petition at this stage.
At this stage.
वो लिखती हूँ.
At this stage.
वो लिखती है.
पर कल को टेक्निकली वो बोलेगा मेरी आपके पास है तो.
Petition is dismissed as withdrawn in the light of the submission from the party. Next case. Shri Ajay Sharma. नहीं लिवर ऐसा नहीं है सर, इसमें बहुत कुछ रहता है. वो कहते हैं फिर जज अपना दिमाग नहीं लगाते. नो अच्छा वो तो कहते हैं ऐसे ही नहीं लगाते. No, Mr. Bhushan, you see liberty cannot be granted as a matter.
In order to put a litigation and party.
That is not the headache of the court, sir. That is for the parties to see.
But substantial justice की वो ठीक रहता है. कि जो केस भी खत्म हो गया, वो पार्टियां भी बांध रहती है कि चलो यार ये दोबारा कौन जाएगा मैं हम यही कर देते हैं.
You see, fortunately for a high court judge, disposal does not matter.
नहीं disposal नहीं, I say.
चलो next case. Yes.
Resolving of the dispute. That is more important.
That is at this stage कर देना. Is allowed to withdraw at this stage. Rajesh Kumar. ये क्या? Where is Mr. Pajulia? आप खजूरिया जी कहता है. हाँ I know that.
My friend from PS saying I am unable to say this thing, and the facts are must be borne out from the record. Now should I submit
who are you? तो आप सिविल कोर्ट गए कभी कि उन्होंने आपका रास्ता रोका हुआ है? कहाँ पे? नहीं मेरे को पहले एक चीज बताओ, जो इतनी ज्यादा घास वगैरह थी वहां पे, उससे कैसे निकलते थे आप? हाँ तो 6 महीने कोर्ट बंद थे. हाँ चलो आई एम अपॉइंटिंग अ लोकल कमिश्नर. 50,000 फीस उसकी, 25,000 पंडित जी की, 25,000 आप दोगे. वो बता देगा कोर्ट को, और जो असलियत होगी उसके हिसाब से फैसला. इंस्ट्रक्शंस दे लो. आप कौन है? 75,000 फीस, 25. और बताओ और किसी ने आना है? हाँ लोकल कमिश्नर थी 25. लोकल कमिश्नर विल गो टू दिस साइट एंड रिपोर्ट आ जाएगी, उसके हिसाब से मैं कर दूंगा. तैयार है? बोलो. मैं नहीं कह रहा सर, लेट दी लोकल कमिश्नर से बोलो. इंप्लीड कर दूं दोनों को, आपको भी इंप्लीड कर देना. वेयर इज योर एप्लीकेशन? एप्लीकेशन कहाँ है? अभी रिकॉर्ड में मंगा दो उसको, आप पूछ लो उससे फोन पे, ठीक है ना? मैं लोकल कमीशन अपॉइंट करेंगे, ठीक है? कॉस्ट होगी वो प्रोपोर्शनेटली बियर करेगी पार्टी। लेट द रिपोर्ट ऑफ द कमिश्नर कम, जिसके पक्ष में बात जाएगी उसकी फीस बाकी पार्टियां पे करेगी। अगर पंडित जी हार गए तो बाकी जो आपसे दिलाऊंगा मैं वे देंगे, और अगर इनके फेवर में गई तो जो पैसे ये दे रहे हैं वो आप देंगे अल्टीमेटली। है मैं लगा दूंगा, चलो दैट्स नॉट, ठीक है, अंडरस्टैंड। आप लो इंस्ट्रक्शंस, आई विल अपॉइंट Mr. Dheeraj Vashist, the senior counsel, is proposing that let Mr. Dheeraj Vashist go as a counsel, go as the court commissioner. Because of his medical issues, it will come to his. आप इंस्ट्रक्शंस देके बता दो मैं अप्रोप्रिएट ऑर्डर पास कर। इनकी 1/10 की दरखास्त होगा, और बधाइयां आपकी 1/10 की दरखास्त अलाउ। नेक्स्ट केस। यस प्लीज, यस मिस्टर राठौर। Yes, commissioner was to pass an affidavit, no? Deputy commissioner, sorry. Mr. AG, इसमें deputy commissioner का affidavit आना था। हाँ, 6 को लगी, आपने क्या किया है? Why has it been listed on? हाँ, हाँ। Why? How you see? Problem is this: how can the High Court, if the authorities are saying that the building is dilapidated, it is unsafe, how can the High Court say that stay the order? My dear, please appreciate. अगर कोई कमिश्नर, अगर कोई रिस्पॉन्सिबल ऑफिसर बोल रहा है that the building has become unsafe for habitation, just 1 minute. हाँ कि इसको डिक्लेयर करो उनसे, तो फिर then it is abuse of the process of law. हाँ, show the application. Thank you. And we constitute an intra-department committee. Don't worry, sir. Don't worry. Let us see his application. मकान की पर्यटन विभाग व अन्य तरफ से गिरने के खतरे वाला। इसमें ऐसा ना, now the problem is you yourself have approached them with this issue कि आपका जो घर है वो because of the tourism department की building के कारण वो उसमें problem आ रही है. They have ratified it. The issue is in the High Court. High Court ने पिछला order जो पास किया है, kindly read that order. The court has directed the deputy commissioner to inform कि किसके कारण ये issue arise हो रहा है. As has been rightly pointed out by the learned additional advocate general, for this purpose the case is listed on 6th. 6 को हम देखेंगे। अगर ये कह रहे हैं कि घर की हालत खराब है, इसको वकेट करो, यू विल हैव टू वकेट इट। हाई कोर्ट नहीं स्टे कर सकता इसको। अगर कल को कुछ नुकसान जो भी है, कल को कोई नुकसान होता है, हाउ कैन आई एज अ हाई कोर्ट जज बेयर दिस ऑन माय कॉन्शियस कि मैंने एक, इन्होंने बोला खाली करो, मैंने स्टे कर दिया और वहां पे कुछ हुआ एंड इसमें कुछ भी नहीं है। हाँ, so वो तो सब जुडिस है ना, इशू दैट द कोर्ट विल डिसाइड। बट इंटरिम में इस एप्लीकेशन से आप क्या कह रहे हैं? What protection? I can understand your client coming to you, but how do you advise them कि एक dilapidated condition के stay के लिए हम हाई कोर्ट आ जाते हैं? Please, how do you advise them? इसका मतलब ये है, should I take it that he is not in a dilapidated condition, उसको खतरा नहीं है, तो फिर please read the prayer. Please read the prayer in the application. Please read the prayer. Stay the operation and effect of letter dated 8/5/25. So what happens if I stay it? इन्होंने जो आपको बोला कि मकान खाली करो क्योंकि कभी भी गिर सकता है, वो स्टे होगा। आप एक ऐसे घर में रहना शुरू रहते रहेंगे जो कभी भी गिर सकता है। हाई कोर्ट नहीं लेगा, इसमें लिखो बाय वे ऑफ दिस एप्लीकेशन अब द फॉलोइंग, ऐसे लिखना, दिस एप्लीकेशन हैज बीन टेकन अप ऑन द रिक्वेस्ट। हाँ, नो आई एम डिसमिसिंग इट, यू हैव टू वकेट इट, आई विल नॉट टेक एनी रिस्क। आपने करना है करो, नहीं करना है ना करो। हाई कोर्ट इज नॉट, you have to take a call. Whosoever is the head of the family has to take a call.
The constituting intra-department committee and intra-department committee submits the report also. Site inspection.
इसमें लिखना by way of this application, the applicant has prayed for the following things. The applicant is the petitioner before this court who has filed this writ petition for issuance of direction to the respondents inter alia to construct a retaining wall below the property of the petitioner to safeguard the same, and also issue direction to the other respondents to ensure that there is proper drainage and sewage system from the adjacent tourism building so that the seepage into the property of the petitioner is stopped. In the backdrop of the relief that has been sought by the petitioner in the main writ petition, have been passed by this court from time to time, and the report that has been filed by the Deputy Commissioner inter alia is to the effect that on account of a building constructed by this then Shimla Development Authority, which is above the house of the petitioner, due to lack of proper channelization of drainage water, more so in rainy season, there is apprehension of damage to the house of the property. On 16th of May 2025, this court had directed Deputy Commissioner Shimla to file as a specific affidavit as to which department of the state has to take remedial measures in this regard. For this purpose, the case is listed on 6/6/2025. In the interregnum, on an application filed by the petitioner to the किसको दी थी application? Corporation को? हाँ? आप corporation को represent करते हैं? हाँ? You are representing the corporation. To the means, हाँ? You are representing to the municipal corporation Shimla. A committee was constituted by the municipal corporation for the inspection of the house of the petitioner, and as the same has been found to be now unsafe, therefore, with a notice dated 8/5/2025, the petitioner has been called upon to vacate the same as the same has become unsafe. The petitioner has filed this application praying for the stay of this order. This court is of the considered view as the corporation on the request made by the petitioner has inspected the property of the petitioner and come to the conclusion that the same is in a dilapidated condition and unsafe for human habitation. The High Court cannot grant stay to the order of vacation passed by the corporation for the reason that tomorrow, if some untoward incident happens, in case the petitioner and his family members continue to occupy the premises, comma, the High Court cannot be a party, cannot become a party by staying order dated 8th of May 2025 to such an to such an unforeseen circumstance. Therefore, this application is dismissed. However, it is clarified that dismissal of this application shall not be having any bearing on the case which the petitioner has filed before this court. Now list on main में लिख देना list on 6025. Yes, please, Vinod Chauhan. Yes, ma'am. What is the case, ma'am?
Your Lordship, in this particular case, partition 2 was there, which we have after the revision petition. Your Lordship, now as per annexure P1.
Okay, then served for 28/5/25. None has put in appearance ex parte. Yes, what is the case, ma'am?
Your Lordship, there was a partition in Your Lordship in which we had got for revision. Now, Your Lordship, as per annexure P1, our case was listed with one another case that has been already decided by the Divisional Commission, Your Lordship. That is on page number 21, Your Lordship. Now, Your Lordship, after this particular decision, Your Lordship, there was no call or nothing had come, no notice to the petitioner, Your Lordship. Thereafter, we filed an RTI as for annexure P2, Your Lordship, in which Your Lordship they stated that
by way of this, by way of this petition, the petitioner has paid for the following. The grievance of the petitioner is that in terms of order dated 12th of October 2010 passed by Divisional Commissioner Mandi, Division Mandi, in a petition filed under Section 54 of the HP Land Consolidation, Prevention and Fragmentation Act 1971, filed by the predecessor in interest of the petitioner. The petition was allowed by the authority and the case was demanded to Tahsildar Sadar Mandi with the direction that the case be decided along with another petition, that is petition number 926 of 2009 titled Gas Singh etc. versus Kim Singh. Yet, despite the fact that this was passed on 12/10/2010 till date, the petitioner has not heard anything from Tahsildar, nor the said case has been decided by the Tahsildar till date. To substantiate this fact, information obtained under the Right to Information Act is appended with the petition. In the light of the said facts, this petition is disposed of with the direction that if the matter post demand has not been decided by the Tahsildar till date, then needful be done by him within a period of 3 months as from the date when the copy of this order shall be intimated to the Tahsildar by the petitioner by adhering to the principles of natural justice. That is not the headache of the court. ठीक है ना? Full stop. Let them come to the court and say it is clarified that the court has not made any observation as far as the merits of the case are concerned. Yes, sir. Reply not filed. Reply not filed. 4 weeks more time period for granted. Interim to continue. Next. Mr. Kuthala. Mr. Vinay Kuthala. all the arguments which were made by the other side are covered by the constitution.
Ask him to join. Mr. Manish, can you hear me, sir? Mr. Manish, can you hear me, sir? उनको बोलो. हाँ, he's there.
Please, Your Honor.
Can you hear me, sir?
Yes, sir, I can hear you.
Application.
Lord, may I respectfully submit, your lordships had heard this matter initially on 27th of March 2025, thereafter on 28th of March, then on 1st of May, and then 2nd May. Thereafter, your lordships were kind enough to hear us on 14th of May, reserve the judgment. Now, my lord, if this application is seen, kindly have para 5 of the application. This application is premised on the fact that a recent judgment has come of the Honorable Supreme Court in SLP Civil number 28104 of 2023, and para 209 of the interplay judgment has been quoted. Lord, with utmost respect, my lord, there is no subsequent event which is necessitated because your lordships have already considered the submission on both sides. The limited issue which
The issue is, as on the date when the judgment will be announced by the court,
please, Your Honor.
the law as it exists on that particular date will have to be, you file a reply there too. You file a reply to this application.
My reply is already ready, my lord. Let that be taken on record, my lord. My only respectful submission is that,
no,
my lord,
now, sir, we'll have to decide the application this way or that way.
I am in your lordship's hand because your lordships have already been kind enough to
Because
give
you
the
see,
party.
just other issues the court will not go into.
Please, Your Honor.
What is the relevance of the judgment being cited to by the learned senior counsel? I'll give an hearing to him and give an hearing to you. That's all. इसके अलावा कुछ भी.
But all that I am requesting is, my lord, if your lordship considers my reply, that suffices the issue, my lord, because
No, but I have to decide the application, sir, this way or that way. Otherwise, either of the party will challenge the order on this ground only.
then in that case, may I only request that your lordship may fix it on the shortest possible date before vacation, my lord.
We'll fix it on. ऐसे करना notice. ऐसे ऐसे लिखो. Judgment was reserved by the court on 14th of May 2025. Thereafter, this application has been filed by the petitioner on the basis of the judgment of the Honorable Supreme Court dated 13/5/2025. With the request that the judgment of the Honorable Supreme Court shall be having some bearing on the issue in dispute. Notice.
Lord, my respectful submission is that the judgment which has been cited in this judgment was delivered in 2023. So there is nothing new which has come in this judgment. That's my submission.
You see, you reduce it in writing. That's what I'm suggesting.
Precisely. I will do that.
Notice reply to the application within 1 week. Rejoinder thereto, if any, within 1 week. List the application for consideration on 17th of June. 17th of June.
Gratefully.
It is released. I am on the next date. Released as a reserved judgment. We'll see on the next date, sir. We'll see on the next date.
Gratefully, Your Honor.
List the application for consideration. On which date? Learned counsel for the party shall also be given an opportunity to make further submissions on merit if so required. So that for that purpose the case is not stretched.
Grateful, Your Honor.
Yes, please. Shri Hemraj. Yes, ma'am. कितने टाइम दिया था आपको पहले? 2 weeks का. Liberty. Yes, please. Subhash. This is also contempt. इसमें क्या डायरेक्शन थी? 8 weeks, 3 weeks. Dr. Nirja. Yes, please. श्री के गुप्ता, इसमें क्या डायरेक्शन थी? Just one notice 4 weeks. कोई बात, इसमें क्या डायरेक्शन थी? उमा पुंदेर है, व्हाट वाज द डायरेक्शन? ओके 3 weeks। मैम आपके में नोटिस एक में नोटिस, एक डिस्पोजल 3 weeks में करेंगे डिसाइड। यस वरिंदर ठाकुर, यस प्लीज। आप नहीं है कौन? जारी है कि नहीं है? हाँ तो बताओ।
Challenge the order passed by the division commissioner, my lord. And he sees first, my lord, for 1 minute the order passed by the before this is subdivision officer by page number E1, page number 27.
How do you explain the delay in coming to the court? You are in the court after 1 year. Huh?
But it will be listed first in my lord.
नहीं ऐसा नहीं हो सकता
These are the
तब भी। चलो नोटिस कर देते, नोटिस
सेम सिमिलर एक प्रश्न और ये भी।
हाँ
उसका टैग कर दो।
उसको बाद में देखें, पहले प्लीडिंग्स कंप्लीट करें।
Because my lord, she has also challenged the
Don't worry, let the pleadings be completed first. 1, 2, 3 सरकार बाकियों को नोटिस रिटर्न फॉर डैश steps within 1 week.
similar issue is present.
Don't worry, let the इसमें डेट्स क्लैश करती है ना, बिकॉज सर्विस करानी है पहले। लेट दी सर्विस भी कंप्लीट, उसके बाद टैगिंग हो जाती है। यस प्लीज, यस प्लीज। युद्धवीर ठाकुर, what is the issue? Acquire the damaged land of the petitioner comprising. Let them approach the committee, है ना? Let the learned counsel NHA come. युद्धवीर, इसमें approach the committee.
Yes, sir.
It was already given them once, your worship. Now there's a prayer for acquisition.
हाँ.
There's a page damage to automatic prayer.
Already raised.
Because if you have already approached the committee, then
Once a committee has given them.
दिखाओ कहाँ है?
कमेटी वाली बात नहीं।
हाँ.
कमेटी उसको
आपको दिया किसने था?
वो उस टाइम कंपनी
हाँ.
और में काइंडली हैव
नहीं तो फिर उसमें now if you when according to you damage was caused to your property?
2015 first time lordship.
हाँ.
When they started construction.
Last time कब हुई?
Last time 2016 onwards they गिरता था।
Okay.
Now it is completely there. Now 2023 report is there also.
हाँ.
This is an action key.
Let them approach the authorities of it. ठीक है. किसको approach कर?
Prayer for acquisition.
नहीं that किसको approach करना है आपने?
There's a committee constituted by the state.
इसमें लिखना by way of this state petition the petitioner has prayed for this following. पहले नोटिस कर दो। एक के लिए एक, दो मैम आप नहीं, you are for one only. 2, 3, 4, 5 state. By the state petition, the petitioner has prayed for the following reasons.
Deputy Commissioner cum chairman has already a part of it.
हाँ.
He has to.
The learned counsel for respondent number 1 submits that the state has already constituted a committee under the chairmanship of Deputy Commissioner Mandi.
By notification dated June 2020.
E39. Page 46.
In notification dated 8th of June 2020, copy whereof is on record as annexure P13. Therefore, in case there is any grievance of the petitioner, he can approach the committee concerned. Learned counsel submits that the petitioner shall approach the committee within 4 weeks, and thereafter committee be directed to decide the representation of the petitioner within some reasonable time. The petition accordingly as agreed is disposed of with the direction that in the event of the petitioner approaching the committee in terms of notification dated so and so within a period of 4 weeks from today. Let appropriate call on the representation of the petitioner be taken by the committee within a period of 3 months as from the date of the receipt of the representation. It goes without saying that the committee shall take into consideration the contentions of all the stakeholders by adhering to the principles of natural justice. Shri K.D. Sood. Okay, Senior Counsel submits that the appellate order is still not available and the case be taken up after 3 weeks. Accordingly, this stuff 4 weeks. Yes, please, Babita. What is the matter? Okay, ma'am, ma'am, prays for some more time to file fresh compliance affidavit. That date will be done within 3 weeks. Pardon, ma'am? ये क्या है? इसमें है क्या? हाँ? वर्क चार्ज इसमें टीम को दे देना 4 weeks तक. Fresh compliance affidavit. Yes, who is for the other side? इसमें लिखना by way of this application filed under order 22 rule 3 of the civil procedure code of prayer has been made to bring on record the legal representatives of the deceased sole decree. No, just on.
The amendment has been filed, Lordship. With the sole proprietor.
To bring on record the legal representatives of the sole proprietor of the petitioner. Senior counsel for the applicant submits that that Shri K.C. Sharma was the sole proprietor of the claimant decree holder. He has passed away on 16/12/2004, and the details of his legal representatives are given in para 3 of the application. Senior counsel accordingly submits that the application be allowed by ordering the substitution of deceased sole proprietor by his legal representatives. In the light of the amendments made in the application, the same is allowed as per. Deceased sole proprietor of the petitioner is ordered to be substituted by his legal representatives whose details are given in penalty of the application. The application stands disposed of. Amended memo parties is ordered to be taken on record. Has put in appearance on behalf of the newly implemented petitioners. Now list for consideration after 4 weeks.
Yes.
Yes, ma'am.
Lordship, this is my application for attachment.
Yes, sir, Babita Kumar.
Wish compliance.
आइए मैम.
नहीं आई जी.
Compliance
जी ये पुरानी वाले जिसमें ये कह रहे हैं कि सूरजमुखी पेंडिंग है लॉर्डशिप.
5 का है ना?
हमारे को तो दी नहीं.
22/5/25 की है.
We don't have the copy lordship.
आप इसको देख लो. Go through it. Pass over. If it suffices your purpose, huh? Yes, Anirudh. For extension of time.
My lords, the SLP has been dismissed on 29th of March. Last time they had prayed for fresh compliance. They have moved some action praying for. The judgment is of 2011. LP has been dismissed in 22.
Judgment kya hai? What is the judgment?
Judgment says because this person had to be granted. It's at page number 13. It starts, my lords. An operative part is at page number 33, paragraph 14. In this case, when the petition has filed the original application, the DPC had not been held, and the learned tribunal permitted the DPC to be held and directed that the result be kept in sealed cover. The result of the petitioner will be accordingly opened, and in case he is found suitable, he shall be granted promotion from the date when the swan number 3 was promoted with all consequential benefits. the needful be done on or before 30th September 2011, and in case the petition is found entitled to promotion,
The needful within 2 weeks. Huh? I'll not give a day after 2 weeks. Okay. By way of this application, a prayer has been made for extension of time to execute the judgment of the court. On the request of learned additional advocate general, 2 weeks time is granted to do the needful, telling which consequences to ensue. List on 18th of June, list on 23rd of June, compliance affidavit in the meeting. Next week.
deeply.
Take a Gupta
Stand complied, Your Lordship.
and submit that the order stands complied with. It is closed disposal.
Lordship, in the earlier matter, they have complied with. हाँ जी.
पिछले वाले ने भी लिख देना, फिर दे देना. इसमें कर देना. The court stands informed that the yes, Mr. Bhushan. Reply not filed. What is the order? Reply not filed. 3 weeks. 3 weeks. There no actual date. Okay, this is. इसमें मैं I'll take you to task if the judgment is not complied with.
Yes.
Actual date. Yes, Mr. Bhushan. ये क्या sir?
So this is also
Dr. Bhushan. इसमें भी reply not filed.
Yes, ma'am.
इसमें direction क्या थी?
They were directed to please, ma'am.
3 weeks. Special.
That's in this manner, I will be permitted to file my power attorney. 2 weeks time, I will be granted to enable me to file my power attorney. We are faced with that peculiar situation also. We're required to file a power.
3 weeks time.
Great. I'm highly obliged. Great.
Yes, please, Uma Devi.
Matter, my lords, that kindly just have the reaction P2, E2, my lords, that the case of the petitioner has been sent to the Office of Accountant General on dated 15 September 2024, my lord, that, but lord, they have supplied.
Pardon?
I'm. They are saying, my lord, that I have not exercised the option within a 60 days, my lord, that otherwise, my lord, that my lordship has already dealt with this issue, my lord, that in Fulmati's case, my lord, that since, my lord, that the order has been passed by this honorable court in their June 2024, my lord. So even wide notification, the state government which has been issued in the year 2023, while they are restoring the old pension, my lord, that so how she could apply within these 60 days, my lord, that so this issue otherwise in Fulmati's case has been dealt with, my lord, that and the coordinate bench has also following the same, my lord, that so. And although, my lord, that she has already paid the dividend amount.
Just for me.
Please, my lord.
आपने जमा करा दिया जो आपने
Please, my lord, kindly just E2, my lord, that
करा दिया सर.
on 9, please, my lord, E2 is the order. With reference to your letter dated so and so, dated 17th August 2020, it is stated that the due dividend amount rupees 1,98,037 has been deposited in the White Treasury on dated till date, my lord.
If it is just a formality, that her option has to be taken as to whether she wants to opt for A or B. Do it within 24 hours. Again, as far as the Office of Accountant General is concerned, but natural, it will go by the documents which are before. Second, when in the judgment it was very clear that in the event of the petitioner depositing this money, it has to be treated.
Please, my lord, in the judgment also.
24 hours. Learned counsel for the Accountant General apprises the court that इनको दिया क्या सर आपने? That gratuity stands released in favor of the petitioner, and as far as pension is concerned, for the want of the option of the petitioner, as to whether the petitioner wants scheme under the old scheme, wants pension under the old scheme or the new scheme. His case is not, he is like a her case. The office is not in a position to release the pension in favor of the petitioner. The counsel for the petitioner submits that in the light of the contents of the judgment, the petitioner has already deposited the due dividend and therefore now there should not be any impediment in the release of the pension in her favor. मैं यहीं से डायरेक्शन दे देता हूँ, treat her case to be under the old pension scheme. आपने under old pension scheme
in terms of the office memorandum 4/5/2023, while they are restoring the old pension.
Learned counsel for the petitioner further submits that it is evident as per the act of the petitioner that she has opted for the release of pension under the old pension. In the light of this development, these proceedings are closed with the direction that the pension of the petitioner be released to her by construing that she has already opted for the old pension scheme, and now the release of pension in favor of the petitioner should not brook any delay.
Within some time on direction.
पहली तारीख को ही मिलेगी ना?
Please, grateful.
Yes. Admitted case. Yes, sole respondent served record. Yes, what is the matter? Permanent. आप आ रहे हैं?
Please, Malad.
Yes.
Appearing vice for Rahul Majan, Malad.
Pardon?
Vice for Rahul Majan, Malad.
मैम और राहुल की प्रेजेंस लगा लेना। वकालतनामा फाइल और वकालतनामा देने।
Power of attorney already filed, sir. Reply के लिए time चाहिए।
वकालतनामा if not filed be filed within 2 weeks. Reply within 4 weeks.
Yes.
This in due course. Shri Udit Kaushik.
Lordship, this is an execution petition wherein judgment dated 22/7/2024 has not been executed by respondent state lordship. In a nutshell, lordship, there was a termination order issued against me which was held bad in the eyes of law and was set aside. Despite giving a representation and everything, lordship,
कुछ कर रहे हैं ये? कर रहे हैं ये? Comply कर रहे हैं? Request a learned additional general list on dash to enable you to provide complaint. 23 June.
much obliged, lordship.
Yes, sir. Sanvanti Hill Construction.
Filing the jointer, they have filed the reply. Otherwise, my lord, there is one. The claims which were raised वो 88 lakh something के थे।
नीचे जाएगा।
हाँ, counter claim तो allow नहीं हुए। 2 counter claim were above 1 crore plus. There is no challenge to the.
Will be determined by the claim or the counter claim.
No. क्योंकि अब तो कब होगा ना? There is a common.
No, if I file a suit for recovery of 5 lakh rupees, can a counter claim be filed there for 5 crore rupees?
File to consider, then that matter has to be shifted.
बताओ मेरे को, मैं तो पूछ रहा हूँ, I don't know.
ये counter claim भी कर सकते हैं, कर लेते हैं।
अभी पूछ लेते हैं। बुलाओ जरा किसी को, सुनीत को बुलाओ जरा। Yes, please. Vishal Sharma. Yes, please.
Pashupati matters. Pashupati. Please. We have moved an early for application for actual date matters in this matter.
What is the matter?
But the matter is that there is a certain scheme comes where petitioner was applied for the sick industries matters. Scheme was for the revival for certain benefits matters. Now, after applying to that in 2008, they agreed to that. Okay, we will forwarding this scheme for the concession matters. Then they rejected that matters. We come to the
petition, my lords, was decided that order sending us back to decide our representation. They decide our representation unreasoned order. Then we file again this course of litigation, which is still pending, my lords. Now, in the recent judgment passed by DB, my lords, they have categorically, this is a judgment, that's why I moved an early hearing application. They have categorically that once the state makes certain schemes or any incentives, they cannot back out from that. This is that order, my lords. That's why I'm moving this application for early.
By an application after 6 months, 19 ki hai writ na?
Please,
we have long pendency.
Please, my lords.
Approach the court after 6 months for early hearing. Eh?
Please,
Learned counsel for the applicant for the application, but with liberty to approach the court for early hearing after 6 months. Then we'll see. ये तो हो गया मेल में लिखना learned additional with some that the office of the this is directed to ensure that the name of the office of the learned advocate general is reflected for the respondent. चलिए इसमें क्या है?
List is over now.
Just 1 minute, sir. Yes. What is the application?
They are saying infringement of copyright and all that.
Yeah, so this is a separate cause. You are separately. इसमें नहीं होगा. This is court has become functus of issue. If you are aggrieved, you can. Maybe, but it is a different issue altogether. You may. I'm not making any observation with regard to the correctness of the issue, but your remedy lies somewhere else. You will have to file. I'm not interested. File a fresh petition. File a fresh petition. You'll have to file fresh petition.
There are three.
No, so question is why should I? You see, I have become functus of issue. Mr. AG, the court has become functus of issue.
Yes.
Now you are aggrieved by the fact. इसमें है क्या grievance क्या आपकी?
Grievance is the
Okay, live streaming. ठीक है, जो भी है, selective streaming. Please file an appropriate application. File an appropriate petition, not application. This rule says that the High Court will, in that case itself, will take.
No, it doesn't have. Honestly, the rule 5.9 was with one provision. Audio, video recording of proceeding by any other beyond the material development is expressly prohibited. Rule 9.
Mr. AG, where have I made an observation that the grievance being raised by the petitioner is not justiciable? I have not said that. No, sorry. You file appropriate proceedings. In plead, इसको करना as a party.
This act is punishable under the contempt of court.
हाँ तो while contempt में file and
I'm paying.
Court is not taking suo motu cognizance.
Yes, that's.
I'm not taking.
Honestly, that may.
तुम्हें approach the court.
Otherwise, we may register and.
तुम्हें Mr. Advocate General, I'm not the Chief Minister. I'm not the person who is going to make any. Just listen. Just listen. We are not perturbed by what happens to our judgments, what happened to our streamings. Court is not concerned with it. Just listen. Just listen. Court is not concerned with it. आपको grievance है, किसी petitioner को grievance है, किसी इंसान को grievance है. Invoke the jurisdiction under the correct fora, under the correct statute. Court will take cognizance of it. I am not saying the court will not. इसमें नहीं होगा.
I'm just relying on.
है ना? नहीं, मैंने पहले भी एक observation. Court is not saying that your grievance is not justiciable. You may be having correct grievance. You may have a correct grievance.
I am only mentioning to my lords that the law of contempt, because my lords are trying to.
Mr. AG, there are two. You see, just listen. There is either a civil contempt or a criminal contempt.
Yes.
Civil contempt is disobedience of a court order. Criminal contempt is interference in the course of the administration of justice. Whatever limited knowledge of contempt I have, criminal contempt cannot be initiated without the permission of the learned advocate general. Ball is in your domain. आपने जो करना करो.
My lords can suo motu.
I will not exercise that. We are not perturbed.
So I am praying that my lords may suo motu.
I am not. We are not going to.
My lords may reject it so that we may take the.
I am not going to. No, I am not going to take it. By way of this application, the applicant has paid for the following reliefs. This court, having heard learned advocate general and taking into consideration the fact that the writ petition already stands disposed of, this court is of the considered view that this court has become functus officio as far as the writ petition is concerned. As far as the issues raised in the application are concerned, in case the petitioner has any, in case the applicant has any grievance, the applicant is well advised to independently approach the court by way of an appropriate application, approach the appropriate court stroke appropriate fora by way of an appropriate application or an appropriate petition for the redressal of the said grievance. However, the prayer made by the learned advocate general that this court should suo motu take cognizance of the events narrated in the application is rejected. Independently, how court may look into it. Court may look into it.
Brought me to the notice of the court. There are rules promulgated by this court.
Next case.
And this court says something which I am trying to bring to the notice of this court.
Mayor Chand Thakur.
Please, Your Lordship. Your Lordship, may I have the annexure A1, Your Lordship, at page 4, Your Lordship. Your Lordship, please, Your Lordship. No, Your Lordship.
Pages of reply in 3 weeks.
Please, Your Lordship.
Please, Your Lord, may kindly have the previous order, Your Lord. May kindly have the order dated 3rd of April 23, Your Lord. They were directed to seek the instructions, Your Lord, but till date,
Yeah, please.
they were directed to seek the instructions, Your Lord, with respect to the payment, Your Lord. Whether, because in view of annexure P8, committee was constituted, Your Lord, and it was decided, rates were decided compensation, Your Lord. I think yes.
ऐसे लिखो केस क्या आपका रिट पिटीशन क्या
Writ petition, Your Lord. In fact, what has happened? The land and the shop of the petitioner was damaged during the construction of the road, Your Lord. The committee was constituted by the respondents, Your Lord, and avoid annexure P8.
And as far as contempt is concerned, Mr. AG, I may say so. The court is really appalled by the kind of lies which are being spoken in the press conference. By मैं नहीं बोलूँगा. By मेरे को नहीं पता.
My lords, may clarify so that because allegations are that I have also conducted a press conference, but I have never.
Just listen.
I have never.
But we are not bothered. And as
No one is bothered, my lord. No one is bothered.
bothered also.
Yes, no one is bothered.
Bothered also.
As an advocate, we always used to say this gown is for this purpose, that whatever we said in the court, outside the court, we are just going and shoulders. So we are not bothered. It is a rules of the court violated. We say we should approach the court first. We could have registered the FIR because it's a case of sensitive nature, as CBI is looking after this case. Therefore, we approach as a cautiously to this honorable court so that matter may not be further politicized.
It is a political fight between you people.
No, it's not a political. Rules are of the High Court.
Next.
Rules of everybody will stream this live streaming. I have no objection for my live streamings. I am ready to it. But once there are rule in place, rules must be followed by all of us, Lordship. And it is equally applicable to my lords to take its suo motu cognizance of this act, Lordship. That is our difficulty. We can register FIR right
land
and the Copyright Act because law permits us. But we want to bring it to the notice of the court tomorrow. It will be that this whatever you played in the name of High Court.
Whatever.
So we are very cautiously moving to the court, Lordship.
We
don't want to play politics on the death.
The land and the shops of the petitioner were damaged during the construction, Your Lord.
It is the correct. But my lord, ज़्यादा नहीं बोल सकता.
Please, Your Lord. The land and shops of the petitioner were damaged during the construction of tunnel, Your Lord. The negotiation meeting was held between the parties, Your Lord. Kindly have an annexure P8 at page 26, Your Lord. They had agreed to give me rates at the rate of 75
100.
The only issue now is,
Yes, your lord.
if you go through the order that was passed by this court on 3/4/2020.
Yes, your lord.
It was agreed that uniform rate of rupees 6,500 per square meter will be paid
Yes, your lord.
by respondent number 4 for the shop and other structure. His grievance is that despite this fact that the rate
They have not paid this.
अभी तक नहीं आया. आपने instructions देनी थी. आप 23 का order, I'll give you some time to have instructions.
ठीक है.
Learned additional tribunal submits that as the case is being listed in the court after the month of April 2023, he may be granted some reasonable time to have instructions in terms of order dated 3/3/2023. That needfully done within 3 weeks.
Some actual detail.
Madam, my name is not reflected in the call.
He is for number 4 and 5, your lord.
वकालतनामा है. Registry is directed to reflect the name of learned counsel for respondents.
Some actual detail, lord. छुट्टियों के बाद.
Like the first. Shri Aman Sood, Pradesh Station.
Matter pertaining to the committed by the Nagar Panchayat with respect to the installation of street lights, high mast lights, and purchasing the furniture, etc. Lordship. The auditor P4 is.
Who are you?
I am a resident of the Nagar Panchayat. Lordship.
What is the next step? P4.
P4 is the complaint. It is the latest complaint, Lordship. P4, page 162.
What is the grievance?
No action has been taken. Please.
Grievance क्या है जिस पे action लेना है?
Point number 3, Lordship. सूचना का अधिकार अधिनियम 2005 में मिली जानकारी के अनुसार नगर पंचायत निर्वाह द्वारा वित्तीय वर्ष 2021-22 से लेकर आज तक अलग अलग समय में स्ट्रीट लाइट्स लगाई गई एवं कुछ लाइट्स की मरम्मत भी कराई गई जिसमें की भारी वित्तीय अनियमितता की गई. And thereafter,
who are you?
I'm the resident of Nagar Panchayat.
File a public interest litigation. For file a public interest litigation, single के पास maintainable नहीं.
This is not.
It is a public interest litigation. What is the relief?
To decide my representation.
No, sorry. ये नहीं है relief आपकी. Representation में क्या चाहते हैं आप?
Action, some action.
ये PIL है.
Then may permit to do.
और इसमें लिखना in the light of the relief prayed for in the writ petition, learned counsel for the petitioner prays for is permitted to withdraw the petition to enable the petitioner to file a fresh petition on the same cause on the format of a public interest. Mr. Goyal, मेरे को एक चीज बताइए. Let us assume that there is a arbitration claim filed for 5 lakh rupees and counter claim filed for 5 crore rupees.
Not going by the analogy of civil suit, a counter claim is in all effects is an independent suit. But here, what I am told by my learned friend, that he has not challenged the dismissal of the counter claim. Neither the party who had filed the counter claim, he has challenged the counter. In effect, because his claim was less than 1 crore, so it would go to the court of competence jurisdiction in the district.
They cannot be clubbed, but ultimately
they cannot be clubbed for the purposes of jurisdiction.
District judge?
District Shimla.
Solan है सर.
नहीं सोलन नहीं शिमला में. वो नहीं आर्बिट्रेशन की सीट ऑफ आर्बिट्रेटर वाज इन शिमला. नहीं जी इसमें कुल साहब थे जस्टिस.
फिर शिमला क्यों आएगा?
यही हुआ ना, यही सीट यही थी मेरी. शिमला ही जाएगा.
ये कौन सा केस है?
Lordship, may kindly see what the mockery they are making, Your Lordship. The case proceeded for in the objections since 2002, and now they say they need more 3 months time to trace the record.
To deposit the money.
Lordship, they have been taking time twice. They have taken time. Lordship, may order the attachment. पैसे भी आ जाएंगे जी फिर with the report of attachment.
How much time reasonably अगर आप जमा करा दोगे 2 हफ्ते में? वो है 23 की वो है 23 का अवार्ड है
2002 का वार्ड है, 23 के ऑब्जेक्शन डिसमिस हुए जी इनके, एग्जीक्यूशन को 1 साल हो गया.
इन्होंने एप्लीकेशन दे दिया फॉर अटैचमेंट.
And my difficulty is my client is a cancer patient, your lordship, and 80 plus, your lordship. He has exhausted all his resources.
2 weeks time इनकी स्टेटमेंट. Okay, इसमें लिखना though today an application has been filed. Though today an application filed by the execution petitioner praying for the attachment of the properties of the judgment that is listed learned advocate general on instruction submits that the hearing of the application be deferred by 2 weeks so that in the interim the award amount can be deposited in the court. Ordered accordingly.
Please, lordship. Please, ma'am.
Let the award amount be deposited along with interest by
Thank
appropriate orders will be passed in the application. ये ले लो आप.
Grateful.
ये तो Mr. AG, as far as your arbitration cases are concerned, आपको एक अलग सेल बनाना चाहिए and depute 3 or 4 additional deputies, especially for that, rather than everyone should be dealing with it. Also, there is one more thing. You see, all these cases are going to come before one judge only, yeah, 2 judges, because these are all commercial matters now. So, rather than it will be in your interest that 1 or 2 additional advocate general, so that they और इसमें department कितने हैं? IPH हो गया, PWD हो गया. इसमें कोई ज्यादा है नहीं. If there is proper liaising between your officers and the law officers of those departments, बहुत जरूरी है. Ultimately, it is the public money which is being.
But normally during the objections, money is deposited by the state. Somehow in some cases.
18% जा रहा है जी.
18% जा रहा है.
Please, Lordship.
Yes, Rana.
The last date of hearing, I was directed to file rejoinder to the amended reply, Lordship. But there is some ambiguity to me, Lordship, that whether there is an amended reply on record, because on the last date of hearing, that took place on 21st of 11/2024, Lordship. The matter was listed before another coordinate bench, and there it was said that reply filed by the respondent to the petition is on record. On that date, I pointed out that copy of the amended reply has been supplied to me if there is an amended reply or not. So I was told that there is no amended reply. And to the main reply, I have already filed rejoinder, Lordship.
आपके अपने दस्तखत है इस पे, रिसीट पे?
रिसीट पे है जी, लेकिन लास्ट टाइम जब कोर्ट में लगा था जी,
हो सकता है कि आपको इन्होंने मेमो पहला पेज दे दिया और बाकी दिया ही नहीं.
नहीं जी, रिप्लाई मुझे दी अमेंडेड रिप्लाई, बट जब कोर्ट में लगा तो वहां मुझे बताया गया कि इन्होंने रिप्लाई नहीं फाइल किया. इवन आई चेक फ्रॉम देयर फाइल, दे सेड देयर इज नो अमेंडेड रिप्लाई.
पर्सनल गुफ्तगू मत किया करो, कोर्ट में ऐसे ही किया करो. अमेंडेड रिप्लाई इज ऑन रिकॉर्ड हियर.
देन आई विल फाइल रिजॉइंडर टू दैट.
देयर इज द क्वेश्चन. ये ऐसा नहीं, इतना भी मत खींचा करो ना.
नहीं, मैं खींचने की कोशिश नहीं कर रहा हूँ जी, बिल्कुल.
On the last date, 23rd of May, rejoinder has been. आप कहते हैं rejoinder to amended reply has been filed.
अमेंडेड रिप्लाई नहीं था, जो मेन रिप्लाई जो पहले इन्होंने फाइल किया था जी.
You made this statement which has been recorded by the court. Learned counsel for this that rejoinder to amended है क्या केस क्या बताओ जरा.
Case, please, Lordship. The land of the petitioner has been utilized by the respondent state for authorized check post and servant quarters, Lordship, and without paying any compensation or without acquiring the land. Firstly, when they filed a reply, they said no, the land, the forest check post is on their land. Now, in amended reply, they say yes, it is on the land of the petitioner, but we have donated it.
Where do they say that you have donated?
Please, Lordship.
और एक कब बनी थी चेक पोस्ट?
I'm on the 73, 74. They say 60, 65, 66.
Disputed issues are civil court जाओ.
मैं तो बोल रहा हूँ 65, 66 ही ले लीजिए. मैं रिजॉइंडर फाइल कर देता हूँ अमेंडेड के लिए.
को कैसे एक्सप्लेन करो?
Sorry, Lord.
Delays and latches.
Delay and latches, I will explain the rejoinder.
Rejoinder to the amended reply has been filed. It is on record.
There must be some miscommunication on my part. Lordship, may kindly grant me 2 weeks time to file rejoinder to the amended reply, because I was under the impression that there was no amended reply. So that's why this situation has arisen.
काम हो गया ज्यादा. आपको यही नहीं पता कि आपने खुद क्या फाइल किया. Your rejoinder is already on.
Rejoinder to the reply only, sir. And Lordship, in that I have annexed the amended reply. I was under the impression that that has never been filed.
Admit.
Obliged.
Admit subject to the objection raised by the Learned Advocate General on delays and levies. Mr. Bhushan.
My lord, apart from the interest, they have paid rest of the things. And my lord, see this one very interesting situation. My lord, may I have this order, my lord. My lord, after this judgment, they filed a review, my lord. My lord, may I have this order, my lord. यार मेरे एक है मैं पैसे दे देता हूँ दिस इज इनको दिखा दीजिए क्या बोले नमाज बख्शाने गए थे क्या बोलते हैं नहीं नमाज बख्शाने गए थे और रोजे गले पड़ गए रोजे गले पड़ गए जी नहीं वो बाकी में तो मैं लड़ नहीं रहा हूँ मैं तो ये इतना
The senior counsel for the petitioner submits that though the judgment in issue now stands complied with, but interest to which the petitioner is entitled to in terms of the order passed in the review petition filed by the state has not yet been paid. Let the needful be done within 3 months with these obligations proceeding.
Please.
Yes, Mr. Mahajan.
Your Lordship, we want
मेरे को review number और date.
Yes, please.
So इसमें record inspect करने के लिए हाँ जी
In a miscellaneous application act, reply to the miscellaneous application not filed be filed within 4 weeks. This thereafter. Kritika Sharma.
Please, Your Lordship.
Yes.
Please, Lords, in this case, Lords, I had come before the court under section 9 because they had retendered the work. Then Lords may have order an annexure P2 on page 11, my Lords. They were restrained to maintain status quo for award of the work, my Lords. The contemptor, my Lords, he proceeded to award the work. This order was passed on 30th of June, my Lords. The contemptor, by annexure A3, page 12, continued to award the work further despite there being an order, my Lords. And this being the only order against him, my Lords. In fact, my Lords may have annexure A5, page 17, because he was an assistant engineer. He was been given the charge of the executive engineer, my Lords. A5 of the same date, 36/2/2023, his appointment has been stated, my Lords. And if my, in fact, without closing my work, my Lords, the work had been put to retender, my Lords. I approached the court under section 9, seeking stay for further award of the work till my work is measured and my accounts are settled, my Lords. The order, which is annexure A2, was passed in my favor, my Lords. And immediately on the date of passing of the order, next date, he proceeded to, despite there being a specific order direction that there will be status quo qua the award of the work, he proceeded to award the work on the very next day, my Lords. If my Lords may have an annexure P4, he even given the additional charge of executive engineer was not competent to award the work, my Lords. Annexure P4, this is the notification of the Public Works Department. And my Lords, if my Lords may have the column 2 in that, he is assistant engineer. Then he can be termed as action non-select on being given additional charge. His competence was only till 1 crore, my Lords. And this work is of 1,88 lakhs, my Lords.
That issue is not.
That issue. Why I'm highlighting this, because there was an intent.
You will have to demonstrate that he was aware of the law.
In fact,
order has been passed in the presence of the Learned Advocate General.
Please, my Lords.
But because order is passed on 30th.
30th, my Lords.
Work is given by him on 1st. It is allotted on 1st.
First, my Lords.
Because contempt has penal consequences. You will have to demonstrate because it is not a disobedience made on him, willful disobedience.
My lord, so far as the order that was conveyed, now my lord,
It is a punitive.
certainly, my lord. Why I'm reading the other two annexure? Because the other annexure P6, if that may be seen,
Mischief. But
he's played a mischief because annexure A5 may be seen. It is by the person who had challenged his appointment was the person in the same office, my lord.
It is a separate issue. You can't.
My lord is right. My lord is right because there is no.
Say that there is a willful disobedience.
My lord, there is no direct evidence to that extent because otherwise he has categorically played mischief.
No doubt will go to the accused.
Otherwise, my lords, because why I have appended, because I am well aware, I have to only rely upon my order. Why I have appended other two annexures? Annexure A5 is by the person sitting in the same room, in the same office, and same order has been passed on that day. That has been conveyed, but still he proceeded because my lord is right. He has placed the mischief very smartly, I'll say. But then again, he was not even competent. So it is
Competence का contempt से क्या लेना?
contempt से कोई लेना देना नहीं. मैं सिर्फ पढ़ा रहा था जी. I was
It is a separate issue. That is on merit.
I bow to my lord's observation to that extent. But the order was passed. Order is conveyed.
What happened after the next incumbent joined?
Next,
Was decided.
any order was not resigned. Then the work was stopped, and there was an order under Section 9 where the work was measured and direction has been issued by the coordinate bench to deposit the amount, my lords.
I don't think there is any willful disobedience proved on it. Man Singh versus Man Singh. By way of this contempt petition, the petitioner has approached this court praying for action against the respondent for willful disobedience of the order passed in arbitration case number 539 of 2023 titled Man Singh versus State of HP and others, dated 3 2003. Learned counsel for the petitioner has drawn the attention of the order passed by this court, which reads as he submitted that despite the status quo order, the award of work passed by the court on 30/6/2023, respondent on 1/7/2023 awarded the work to Mahinder Rana, which amounts to willful disobedience of the directions passed by. Learned Learned Advocate General, on the contrary, the Learned Advocate General, by referring to the reply, has submitted that though it is a matter of record that this court was pleased to pass status quo order on 30th of June 2023, but then there is nothing on record from which it can be inferred that the order indeed was conveyed to the officer concerned who allegedly has committed the contempt of the court. Learned Advocate General further submitted that though the presence of the Learned Additional Advocate General has been marked, but as a matter of record, the order was not conveyed to the officer before 1st of July 2020. Okay? Accordingly, Learned Advocate General submits that maybe disobedience of the court order is there, but willful disobedience is not there. I have heard learned counsel for the petitioner as well as Learned Advocate General. The petitioner alleges willful disobedience of the direction of status quo passed by this court on 30th of June 2023. Violation thereof, as alleged, is in terms of annexure A3, which work was allotted by the respondent contemner to a government contractor on 1/7/2023 despite status quo order passed by the court. This court is of the considered view that because contempt proceedings are punitive in nature, therefore, until and unless it stands demonstrated before the court that the order has not only been violated, but there is a willful disobedience, there has not only been disobeyed, but the disobedience is willful. Contempt proceedings, the court should refrain from taking action against a person in exercise of powers of contempt conferred upon it. In this case, though, it is clearly borne out from the document that despite the status quo order passed by the court on 30/6/2023, the work was allotted by the respondent to a government contractor on 1/7/2023, but the petitioner has not been able to establish that this was done by the private respondent, despite the factum of his having knowledge of the order passed by the court on 6/2020. That being the case, this court cannot, on the basis of conjectures, come to the conclusion that the disobedience of the court order is willful. Therefore, in the facts of the case, as this court concurs with the submission of the learned advocate general that the petitioner has not been able to establish that there is a willful disobedience of the court order. Petition is dismissed, notice discharged. Challenge.
My lords, may just say that it shall not affect at any outcome of the arbitration proceedings going on.
It goes without saying that the observations made in this petition are limited to the adjudication of this petition, and they shall not be having any bearing on the pending arbitration proceedings. Shri B.M. Chauhan. Yes, please.
Lordship, in this reply has been filed. I am seeking 2 weeks time to file rejoinder.
Case kya, sir?
Lordship, petitioner is challenging the order dated.
Okay, no problem. Reply stands fine. Rejoinder within 4 weeks.
Grateful.
Yes, sir. Sanjay Bhadra.
Yesterday, the LPA was listed. LPA on those same was dismissed on delay, but order is not uploaded yet. But honorable court has observed that since we have already passed an order on merit consideration order, therefore you may plead this before the honorable.
I have been asked to refrain from.
No, nothing is done. Just that pleading, I'll want to bring that to the notice of my lord. That order is not uploaded yet. So my lords may take it next week so that I may.
Yes, it can be taken. Otherwise, the last opportunity was given.
We have passed the order, lordship. My lords have directed us to consider the case from April 2011 for work charge status. We have said that since he was on bill basis, lordship, so he was not entitled for. We passed that order, lordship.
So LPA में हुआ क्या है?
That has been dismissed.
LPA dismissed on delay, but it is stated.
Your Lordship, let it be taken next week. Yes, I think that would be more appropriate. Let me also go.
On the list on 18th of June as well. Compliance affidavit.
Last opportunity was given, Your Lordship. It may come, Your Lordship.
We have filed a compliance affidavit, but my lord say that order passed by us. We are relying on MD.
Simply लिखा देता हूँ. ऐसे लिखना list on 18th of June as printed. कोई observation नहीं sir.
Otherwise, you see, as per the previous order passed by this on court, they were granted last opportunity to comply with
the. We have filed one CMP also to permit to withdraw the order passed on merit and permit us to file pass a fresh order.
आप उसके बीच में जो करना कर देना to comply with the.
मतलब we can pass a fresh order if my lord's permit.
You pass a. What is the direction passed by the?
Direction, my lord's for a moment. Direction is consider.
The judgment has retained finality.
Yes, sir. That is the.
Pass a fresh order in compliance there too.
We have passed a for
earlier order passed.
Now they are taking the plea that since the petitioner was engaged on bill basis, therefore he is not entitled to the relief.
Page 21, para 7, lordship.
Just one.
Of the judgment. Accordingly, the petition is disposed of with the direction.
Acquisition proceeding.
This is also my matter.
Madan Lal.
Madan Lal.
Actually, is disposed of with the direction that
the department will calculate the number of days that have been put by the petitioner from the month January 2011, and in case he fulfills the criteria of concurrent work station, having put in 8 years continuous service duty 40 days in each calendar, then work charge.
से आप जी एक चीज का ध्यान रखना, और rightly or wrongly your plea of bill basis has been rejected.
Yes, sir.
आप उसको नहीं कर पाएंगे.
But we say that he is not fulfilling that criteria of 8 years.
वो अलग चीज है.
That is, we have said.
Independently, if you can establish that thing, then
that we have established.
Then also not clear.
That we have established that in some years.
Kindly see the order dated 12th of December 2024 passed by this court.
And for some days he was paid for only.
Only thing which the court, on the hindsight, if I can correctly remember, is that by giving the nomenclature of bill basis, you cannot usurp the right of regularization if it befalls upon the petitioner.
Yes, sir.
As per the policy of the state government.
State government.
Now the court has directed you that consider his case for work charge if he fulfills the eligibility.
Yes, sir.
But he doesn't fulfill.
That
have come to.
That is a different issue. That has not got nothing to do.
That we have come to.
That is what I have observed. You can pass an order in terms of the judgment passed.
He have passed the.
You may pass an order.
Please.
ये हरे कृष्ण क्या है?
Lordship, in this case, Lordship, these were
ये नहीं कराना सीनियर से.
ऐसा कुछ नहीं. Kindly see page number 11, Lordship.
Yes.
Yeah.
Yes, please. ये क्या है, sir?
Lordship.
In the subject matter. In the instant case SLP. इसमें डायरेक्शन क्या है संजय?
Lordship, they have been directed to initiate the acquisition proceeding, Lordship. Kindly see page number 11, Lordship.
No, but if they have filed an SLP.
These were two matters, Lordship, which were decided together, Lordship.
तो एक चीज ये बताओ, whether in this particular case SLP is pending or not.
That is with them, but otherwise, Lordship, what I am submitting, Lordship.
कह रहे हो ना?
In the connected matter, Lordship, they are in process to issue the notification, Lordship.
I am not interested in connected matter.
Yes,
I'm
Lordship.
interested in this matter. They say that SLP 27072 of those are purchased diary number. कर दिए इन्होंने तो wait for some.
ठीक है जी.
Learned additional to get general on the basis of instructions received from Executive Engineer Arki Division HPPWD Arki apprises the court that the specially petition has been preferred by the state with a diary number 270-72/2025, which is yet to be listed before the Honorable Supreme Court. He prays that the hearing of the case be kindly deferred by some time. List after 6 weeks to await the outcome of the SC. Yes, Miss Anu.
Whereby I was a student of BA second year and I was not allowed to sit in the exam as there was a gap in my education. The university has filed its reply and number 2 and 3 have as yet not filed their reply.
What is your case? बताइए.
Please, Lord.
कौन से कोर्स में एडमिशन ली थी आपने?
My lord, I was studying in BA second year at Government College, Nerva.
BA second year. When did you take admission?
My lord.
BA में कब एडमिशन ली थी आप?
I took admission in BA in the year 2019-20 academic session.
2019-20.
Please, your lordship. I passed my BA first year in the year 2020. Thereby, I had lordship. May kindly see annexure P3.
University, आपका क्या stand है?
Lordship, as per our reply, Lordship, may have para 2. We say, Lordship, the notification as printed in the writ petition dated 27/9/23 is not applicable to the petitioner as the same is for final year students, not for the students like the petitioner who are in the second year examination.
No, as per your statutes, within what duration the course is to be completed?
Shall not exceed 3 years, Lordship. I have reproduced in my reply.
Okay.
Because my Lord may have my reply. And may have internal page number 3.
Step to correction, 6 years period is there. I've already decided a case last week.
Your Lordship.
आपके statutes के हिसाब से 6 साल में course पूरा करना होता है.
And the 5.4 clause is not applicable to the present case.
5.4 क्या मैम?
It is the clause which has been elucidated in the reply itself at page number 3 of their reply, para 3. May I read? Save as elsewhere provided in examination in which a candidate has to appear to complete the.
हमिंदर को बुलाओ जरा हमिंदर चिंदे को. हमिंदर के केस पे जब भी जजमेंट दी थी ना पिछले हफ्ते, जिसमें वो MBA का स्टूडेंट बोल रहा था कि मेरे को लास्ट सेमेस्टर का पेपर देने दो. वो जो एक HAS ऑफिसर है लड़का, he was saying ना that allow me to sit. तो उसमें जो इन्होंने इंस्ट्रक्शन जो स्टैट्यूट दिखाया है, उसमें 6 years period is there ma'am to complete the course. If that is so, that is why the first query I posed to you was कि एडमिशन कब हुई है? 2020. Then the incumbent, subject to correction, incumbent can pass the course in 6 years.
Please allow.
मैम आप लाओ ना होमवर्क आपको करना मैनेज नहीं करना.
Please allow.
लेकर आओ वो फर्स्ट
मैं लेके आती हूँ.
इनसे स्टैट्यूट और ऑर्डिनेंस निकाल लो.
Please allow. I'll bring that.
पास ओवर कर दो.
Please allow. I'm good.
Yes, please, Sohail. Ajay Thakur. Madan Lal.
Please allow.
Yes, please.
Lordship, this matter, Lordship, reply is still awaited for respond number 6 and 7. Lordship, this is that respond number 6 and 7. Lordship, they started awaiting and gave waiting to the persons. Lordship, that is one of me. Lordship, and Lordship, that the that the responder 6 and 7 was arrested by police, Lordship, but they were in the police custody under judicial order 28/3/2024, and Lordship, they were discharged
by the police at their own and were released on intermediate night on 27 and 28th, Lordship, March 24. And Lordship, thereafter, and which my appeal is there, Lordship, that may be taken from respondents 3, 4, and 5, Lordship. Supervised officer may be ordered to hand it over, and special investigation team to the handed by the senior officer, Lordship, for investigation, Lordship. And Lordship, respond number 1 to 5 reply already filed, and Lordship.
6 and 7 is written.
And 6 and 7 is.
What is your allegation against the police? Why should the investigation be handed over to someone else?
इनको जी जुडिशियल कस्टडी में 28/3/2024 तक बोला था जी, और इन्होंने इंटरमीडिएट में ही इनको रिलीज कर दिया, दैट इज 27 और 28 के बीच में, लॉर्डशिप। तो
कोर्ट को जाके बोलो, जिसने किया था जुडिशियल, जिसका ऑर्डर फ्लाउट किया उन्होंने, वहां पे जाके बताओ व्हाट इज द रोल ऑफ द हाई कोर्ट अंडर आर्टिकल 220।
लॉर्डशिप फॉर इन्वेस्टिगेशन के लिए लॉर्डशिप, अदरवाइज लॉर्डशिप रिप्लाई
कोर्ट इन्वेस्टिगेशन के ऑर्डर के लिए एसआईटी बना दो, ये कर दो, वो कर दो। You can't come to the High Court at the drop of the hat.
Otherwise, Lordship reply आ जाता तो फिर।
You will have to make out a case ना, किस चीज के लिए, क्योंकि जब तक एक केस यहाँ पे पेंडिंग है, नीचे भी कुछ नहीं करना किसी ने डर के मारे कि हाई कोर्ट में पेंडिंग है केस।
But Lordship, respondent 6 and 7 is released on bail, Lordship.
Respondent 6 and 7 का लेना देना ही कुछ नहीं है। Your grievances against them, उसमें से एक तो abscond कर लो तो पकड़ा ही नहीं जा रहा है, वो तो आएंगे भी नहीं कभी, तो ये तो आर्ग्यू करो मेरिट पे।
और फिर एक हफ्ते के बाद
इतना इंपॉर्टेंट केस मिला आपको, आर्ग्यू करो।
Lordship, I am not properly reading, Lordship, so one big time.
On the request of ma'am, list on dash. In the meanwhile, petitioner will join to the reply filed by respondent 1 to 5. Endeavor shall be made by the court to hear the case on matter. Try के date लगा। हाँ? ट्राई की डेट। नवीन कुमार। ये क्या है सर? मणिक सेठी।
In this case, order dated 1st January maybe.
Okay, what is the issue?
Issue is knowledge a land has been transferred in the name of government under the HP Land Sealing Act without there being any order, any proceedings.
Who are you?
Well, I am the person whose land has been. When I got to know, I approached the concerned authorities under Land Sealing Act as well as.
What is the situation? What is the position of the?
Well, it's in their name. Entries are in there.
Ladies की क्या position है?
Complete. ये सिर्फ इन्होंने record लाने because it was argued on the previous date and पिछले इनको कहा था कि record लेके आओ, कहाँ से आप कह रहे हो कि आपने land इनकी there is a proceeding.
Application.
Amended memo of parties का.
नहीं CMP for placing अच्छा this application is disposed of by ordering that the amended memo of parties be taken on the court.
They need to comply with order. Just एक बार 1st January. No, my lord, because the issue is only of this small thing that there are no proceedings. They have admitted in their reply.
You want to file the
journal? We have already made a statement. It is recorded. My lord may have 16th December on.
This for consideration after 4 weeks.
मतलब previous order में भी कम। एक बार 1st January का order देख लो। वो थोड़ा important। 1st January last।
Order लाना इन्होंने।
है वो है।
कैसे लिखना पहले तो application list on dash जुलाई की date दे देना on which date record in terms of order dated 1st of January 2025 shall be made available for the perusal of the court. जुलाई की date second third.
कौन सी जुलाई?
File the reply R5 in this matter.
Yes.
They have filed reply.
कोई जल्दी की date. Yes.
They have filed reply yesterday.
Reply 1 to 5 on record.
I have filed my reply yesterday, my lords, for 6 and 7.
सब आप किसके लिए?
R5 my lord.
आपका तो रिकॉर्ड. What is the matter?
I'm seeking a time to file rejoinder, Your Lordship.
Issue क्या है? Land
So is Your Lordship, they have they
आप किसके लिए?
6 and 7 के लिए, my lord.
How to file reply?
I have filed yesterday, my lords, my reply.
Reply of respondents 1 to 5 is on record. Learned counsel appearing for respondents 6 and 7 submits. नहीं, so इसमें लिखो reply on behalf of respondents 1 to 7 is on record. Rejoinder thereto if any within 4 weeks.
All right.
Pradesh Sharma, Manlal.
This is the poultry farm.
Poultry farm. हाँ जी sir.
pass it over, my lords. This is to be argued by Mr. Sharma. He's on his legs before Honorable the Chief.
Okay, no. Yes, Chaudhary sir.
Pleasure.
ये क्या है sir?
Respondents have filed the reply.
Lordships had raised the query on the last date of hearing whether this petition would be maintainable in view of the reliefs claim because it's in the nature of a PIL.
Case क्या है sir? Relief क्या है sir?
To take action against the illegal mining and other. But till date, now I will take my lord to next. That is page 229. This is the water report.
No, who are you?
I'm a resident of that.
Public, you will have to file a public interest.
I see my lord. That since due to the fact that the notification has not been implemented and the private people are harming the ecology and environment.
हाँ तो ये सर आप बहुत बड़े आदमी हैं. आपके केस सिर्फ प्रिंसिपल डिग्री सुन सकती है. हमारे जैसे छोटे जज नहीं सुन सकते. नहीं वो तो मेरे को पता है. मैं अपने को भी यही बोलता हूँ. You will have to file a public interest litigation and therein also you see in the writ petition mandamuses cannot be issued by this court के NGT का order implement करो या क्या. You have separate.
Here also a writ petition is filed. File a order passed by the Honorable Court.
Due to this factor, the discussion of the environment ecology.
Mr. Chaudhary, please educate us. What is a public interest litigation?
Public interest litigation wherein the interest of public is involved.
So does the issue of ecology and environment affect the general public or not? So then you have to file a public interest. ऐसे लिखना by way of this petition, the petitioner has prayed for the following release. During the course of the hearing of this petition, this court made an observation that as the petition has been filed in the nature of that, as the petitioner has raised issues of public importance, therefore, ऐसे लिखना. During the hearing of the case of the petitioner, learned counsel for the respondents have taken an objection with regard to the maintainability of the petition on the ground that the petitioner is a busybody. ठीक है sir? Be that as it be. Otherwise, also taking into consideration the fact that the petitioner otherwise has filed this petition more so in public interest as a pro bono. At this stage, on the request of the learned counsel for the petition, this petition is allowed to be withdrawn with liberty to the petitioner to file a petition on the format of a public interest.
My presence is Mr.
सबकी लगा दो.
Number 7.
खुद लिखा दो सब. Yes, Tomar साहब. Rejoinder not filed. 2 weeks more time granted. Yes, Mr. Mahesh Thakur. Yes, please, Vipin Kumar.
My lordship appearing
Not
for
Thakur.
respondent
Pardon,
number
sir?
3. I'm appearing for respondent number 3 also.
I'm आपके इसके
time to file reply.
You are for whom?
We are withdrawing your lordship this petition.
Learned counsel for the, you are for whom?
I'm already.
Okay, then present run. Place for that he has instructions to withdraw the petition this. Tell it. Anuj, are 3 and 4 served? हाँ.
Lord, I'm appealing for respondent number 3, my lord.
Okay, 3 के लिए विशेष जी
Please, my lord, I'll be paying for 3 and 5.
4 के लिए कौन आ रहा है? CEO. चार का जवाब आ गया? किसके वकालतनामे पे है? हैं? Okay. 4 के लिए AG साहब बता दो. Yes, what do you say? हाँ. क्या है कि Yes, please.
In fact, the issue was that the people has not found that a drainage system was placed by the pond, which is to elevation, resulting in waterlogging. The waterlogging in lordship I have based on report by way of photograph, which are at page number 24 and 25. Because the monsoons are almost setting in. If taking another report directing the respondent number 1 and 3, you please inquire into it why this was not happening. So if you want to see the program at page 24 and 25.
आपके रिलीफ क्या है?
This is relief number 3. Respondent number 3 can be directly to hospital expert committee in order to discover the reasons for waterlogging which was found at the spot, and also to give a report as to how it proposing to prevent any further.
तो आपकी जो मेन रिलीफ है ना सर, और जो आप रिलीफ इसमें मांग रहे हैं वो सेम है. What I'll do is इसको तो आप रूटीन में फाइल करते हो. Taking into consideration the issue involved, I'll direct him to file a reply within 2 weeks.
Please, Lord. We'll do that.
हमने reply मंगा लेते हैं फिर देख लेते हैं.
Please, Lord.
Immediately after the vacation.
My lord, please.
One of the respondents has endorsed to this fact. Lordship would have NHPA at page 41.
असली कौन है इसमें काम करने वाला? असली किसने काम? R3 तो ये बशीर जी को
My lord, I will take a call on this. Sir. We'll take a call.
presence लगा देना सबकी. List on dash. In the meanwhile, learn counsel for the respondents to file replies to have instructions in the light of the relief prayed for in the petition.
Please, Lord. Please.
आप ये रिप्लाई फाइल कर दो इसमें.
हाँ कर दो.
आपकी प्रेयर सेम है इसमें अनुज, जो मेन है ये. दिक्कत ये है ना, अब ऑनेस्टली स्पीकिंग गॉड नोज, हो सकता है कि आपका जो कंस्ट्रक्शन है फैक्ट्री का, दैट इटसेल्फ में बी रिस्पांसिबल फॉर वाटर लॉगिंग.
Inherent.
ये भी तो एक इशू है ना सर.
One of the respondents has candidly admitted to this fact that the drainage system could be break by the.
No, that is उसमें तो
But we shall look into it.
Existing before my factory came. When I constructed my factory, everything was all right. Once this new drainage system was put into place, all these problems have started to occur. So it was not a case from the very beginning. It has been subsequently that it gets started.
Please, Lord.
let them file reply.
Lord.
You are powerful people. Yes, please.
In this Lord, I am appealing.
10, 12, 13 served. Huh?
I am appealing for respondent number 7 to 10 and 12 and 13. I am filing this memo. I will file power of attorney within 2 days.
What do you say?
I received this file today in the morning, so I could not go through the file now.
Do you have instructions as to whether your clients are indulging in the activities which are alleged in the writ petition or not? पूछो इनको. Will dispose of the petition by making order dated 1/4/2025 as absolute.
Then Lord, it may be kept after 2 days.
We'll take it up at 2 p.m. Have instructions. आपके client बोलेंगे अब ऐसा कुछ नहीं कर रहे हैं. We'll just record it and dispose it off. Yes, please. Vikrant. What is the issue?
Payment query tender. I received final payment, however, the payments have still not been made by the executive.
Yes. क्या instruction? आपने instructions लेनी है क्यों नहीं ले रहे हैं? अगर कोई admitted amount है बताओ नहीं है तो then we delegate them to civil court. And on the request of learned judiciary, you list on Wednesday to enable him to have instructions. इनको लटकाओ मत ना किसी को डिस्कस करें. Yes, Pandit ji.
My lord, I have filed power of attorney for respondent number 5, my lord. My lord, for which time is given to file that.
Okay. R5 stands served. Mr. Pals has put in appearance on his behalf. The reply is paid for in 4 weeks. Mr. After interim to country. Okay. Yes, please. Chauhan sir.
They were to place on record their.
Yeah, after the reply sent for signature, Lordship, may take this matter day after.
Yes, Chauhan sir.
Yeah, permit है, below permit they
Okay.
apply.
Learned counsel for respondents 4 and 5. Praise that the case be taken up on Tuesday, by which time he submits that he reply will be ordered upon. Yes, sir. Sign the name.
I want to take respond of the 6.
वो कौन है? 6 का भी यही आ रहा है.
SMD है जी. Chief Officer, SMD
है 6 नंबर कोई. Presence लगा देना. Suman, reply not filed. Yes, please. What are your instructions? इसमें instructions तो 2 बजे. दो सर. दिखाओ जरा रिप्लाई की. आपके the issues relating to civil hospital Dharmor. Civil hospital Dharmor में डॉक्टर्स की क्या पोजीशन है? Sanction strength क्या है ये बताइए, है ना?
Sanction strength is 65.
CH community health center Dharmor की मैम?
Civil hospital Dharmor.
एक BMO, 11 medical officers, dental surgeon. These are the doctors. Then chief pharmacist A, pharmacist Char, pharmacist Winter, ward sister, staff nurse, ophthalmic officer, lab assistant, dental. इसमें से खाली क्या है? BMO की पोस्ट खाली है. मेडिकल. अब पहली चीज आप ये बताइए कि BMO की पोस्ट तो 15 से खाली चली आ रही है. So why are you raking up this issue now only? Why didn't the petitioner not make any effort to have this post filled up during the previous regime?
Earlier there was another post, field staff was there.
नहीं, आपका जो
field staff as well as the main staff, all are there. And this issue has been raised categorically that is a hard area and only one doctor is taking care of the PCH.
See, the petitioner before the court is a member of legislative.
Yes, sir, that's true.
So this particular regime is there for the last 2.5 years. BMO was not there since 2015,
Yes, sir.
including the period when the other regime was in power,
Yes, sir.
other party was in power.
Yes, sir.
आपने तब क्या endeavor किया वहाँ पे BMO?
Lordship, but other posts are also lying in place.
दूसरों का करते हैं, दूसरों का लेते हैं. So BMO as of now it's not a priority.
Dental surgery. Don't worry. Dental, आपका दांत खराब है? Do you have any problem with your tooth? No. पहले medical officer पे आओ ना, वो ज़्यादा जरूरी है. Out of 11, 9 are line vacant. 9 posts are line vacant. तो इनको भरो. Why are you not filling up?
It is really difficult to manage the whole hospital on the basis of
Or it is. That is absolutely. Whosoever has visited it knows how difficult the terrain is. Yes. Number two, it is not the issue of Bharmor. Bharmor feeds to the remotest of the areas of that particular district. Yes. ये Bharmor centric नहीं है litigation. There are people उनके लिए जिनके लिए नई दिल्ली Bharmor है.
So they have appointed doctors in district Bilaspur, which are well fitted by private hospitals also and other facilities also. AIMS are also there. But here only CH is there and some health centers are there. And even the purpose of the female who are about to in pregnancy line of children, the single doctor is making delivery of these females. And she is working day and night.
आपकी your petition is restricted to Bharmor only?
In Bharmor there are other areas also, like Kuguti, Badagra, Mantha, Kulan, Chodia, Lahar, Rima, Harsar, all areas. In all areas, only class 4 workers is there.
No medical office.
No medical office. Even the female health worker is not there.
So, paragraph this petition, the petitioner has highlighted the issue of the paucity of medical officers and other staff in Civil Hospital Bharmor, as well as
CH, Community Health Center.
Community Health Center and primary health centers in and around Bharmor, i.e. CHC Holi, PHC Garola, PHC Mandha and PHC Jagat. ठीक है? Full stop. The full stop. Annexure P1 depicts the staff position as on 30th of April 2025, which, to say the least, is disturbing. Annexure P1 and P2, which is staff position, which to say the least is disturbing. This court can take judicial notice of the fact that CH Bharmor is situated in the tribal area of district Chamba, and other CHCs and PHCs referred to in the petition are also in remote tribal areas of the district, catering to the residents of the state who live in extreme remote, who live in remote areas and under extreme weather. For example, out of 65 posts in Civil Hospital Bharmor, 35 are vacant, which does not include the field staff. Full stop. Against 11 sanctioned posts of medical officers, only 2 are posted since 14/9/2023,
The only post of dental surgeon is lying vacant since 5/9/21. The post of chief pharmacist is vacant since 2016. Three posts of pharmacists are lying vacant. Three posts of pharmacist winter are lying vacant. 6 posts of staff nurse are lying vacant, etc., etc. Same is the position with regard to the other, the CHCs and PHCs. Though the reply filed by the state is not on record, but the court has perused a copy of the reply filed by the state, and contents thereof are not very assuring. Accordingly, this case is ordered to be listed on 17th of June 2025 with direction to the learned Additional Advocate General, with direction to Secretary Health and Family Welfare to the Government of Himachal Pradesh to make an endeavor with a direction to the so-and-so to ensure that adequate number of medical officers and other doctors are posted in the CHCs and PHCs as well as civil hospital, Bharmor, and minimum 50% of the sanctioned strength is ensured at said places. Okay? Full stop. Where the sanctioned strength is one only, there the medical officer, stroke doctor concerned, stroke nurse concerned, will be posted forthwith. List for compliance on dash. आप कम से कम ऐसे ना 11 की जगह 2 हैं, 4 5 तो लगा दो ना, ये नहीं है कि सारी की सारी भर दो, हैं? ये दे दो। हाँ, वही है, तभी मैं कह रहा हूँ कि
we will do the needful loss. Otherwise, there remains left over for the 5 years. And now
को देख के मेरे को लग रहा है कि कल पता चलेगा कि पुष्पिंदर ने खुद ही बाइट काउंट डाला।
what I am saying, Lord,
डॉक्टर तो मिला नहीं, सर मैं आ गया हूँ।
there remains left over the matter of 5 years, and now they have come with the. Although it is irrelevant.
इसके बाद है 23 के।
नहीं जी, अब देखो, why not make I see? But we will do the needful loss.
Petitioner raised this issue as many as.
Petitioner is a member of.
We all know petitioner was previously a doctor.
Yes, Lord.
He was a doctor.
Yes, Lord.
Yes, recently fought the election.
But Lord, he was active. I don't want to comment.
He was
active involved in politics.
मैंने वीडियो वाला इशू रेज नहीं किया, जैसे कह रहे हैं ना कि ब्लॉक डेवलपमेंट ऑफिसर भी लगाओ वीडियो को, मैंने वो मैम को क्वेश्चन किया क्या 15 साल।
I am not on that point.
प्रॉब्लम पता क्या है? You see, issue is not whether A is the MLA or B is the MLA. मेरे को आप ये बताओ कि क्या ये जो जितने आपके मिनिस्टर्स और MLAs हैं ना, and including your advocate general and additional advocate general and including judges also बोलेंगे, ये थोड़े जाते हैं हॉस्पिटल।
ये खाली रहने नहीं चाहिए। I am of the view they should not remain.
Meant for the poorest of the
people. Please, that is true.
Ultimately तो उन लोगों के लिए है ना सर जो या तो अब ये भी आपकी प्ली हो सकती है कि वहां की जो पॉपुलेशन वगैरह है उसके हिसाब से 11 बनते ही नहीं है, 5 बनते हैं और हमने 5 लगाए हुए, ये भी हो सकता है। बट अगर 11 की जगह आप 1 रख रहे हैं तो दैट इज स्लाइटली। श्री अनुज गुप्ता राजीव सूद, ये क्या सर? ये वही वाला इशू है।
हाँ जी।
बताओ सर। Whether the termination of the service.
Page number 11 is was the claim of the workmen that they were employed today in 1992 and they were allowed to work till the year 2005. The petitioners were appointed as tax collector by the government. Tax collector for what purpose, Lordship? They had in fact built a bus stop. The vehicle which used to be parked in that bus stop, we used to collect taxes from. Now, in the year 2005, Lordship, all of these petitioners, they were retrenched without following the due process of law, without following Section 20. They raised a demand. The demand was then referred to the industry court, and a reference was set. The reference was
You see, there is one problem with the award. Please come to para 12 thereof. Let us read para 12 of the award.
on the failure of
Please read it.
on failure of the petitioners to attend the office and to deposit the amount notice they exhibit so and so and so and so during the period were issued to them to explain their payment. The petitioners did not file reply to such notices. The termination of the petitioners in such a situation cannot be held to be illegal, especially.
See, the problem is, assuming the petitioners are not workmen, then the learned labor court should have simply said that because they are not workmen, the reference sent, वो तो खैर मैंने पिछले टाइम क्वेश्चन रेज किया कि whether he can go beyond the reference, वो मैं सुनूंगा. He should have simply said कि sir because they are not workmen, therefore reference is answered accordingly. How can he say कि उनकी जो retrenchment are justified है या termination?
My lord, what I am submitting, if my lord have the Panchayati Raj Act, kindly have the.
So forget it. Let us see the jurisdiction of the labor court as to whether in the absence of this issue being there in the reference, can the labor court dwell on it? उसको देखते हैं sir.
My lord, what is the reference? The reference was whether the termination of services of Sarvashri Jasmeer Singh Devinder Chand without serving charge sheet and without holding any domestic inquiry, without complying the provision of Industrial Dispute Act 1947 is proper and justified. If not, what relief benefit amount of compensation above agreed workmen are entitled to? Now, your lordship, what I am submitting, once the reference was made to the labor court, I have filed the reply. I have raised the point of jurisdiction. That labor court has no jurisdiction since the panchayat does not fall within the definition of industry. And that before proceeding further, your lordship, the labor court was required to decide whether the panchayat is an industry or not.
So that is exactly what I am asking you. That until and unless the reference.
My lord, I have the.
Judgment.
My lord, I have the judgment on this point. I'm asking. My lord, this is Supreme Court. Last. My lord may have para 8 of this judgment. I am marked with pencil mark. This is Supreme Court.
ये निकालना जरा 19 सुप्रीम कोर्ट की जजमेंट कौन सी है?
My lord, this Supreme Court is this. This is Supreme.
Do you have a judgment?
Our High Court has
ये मार्क किया सर मैंने. भेज देना फिर. मेरी जजमेंट कर.
ये निकाल दिया सर सुप्रीम कोर्ट की जजमेंट. AIR 1963, सुप्रीम कोर्ट 569. ये निकालो. राजेंद्र जी ये निकालो जरा. आप बताओ सर कौन सी बोलते हैं?
नगर पंचायत do this whether it is sovereign function or not. But once
No, but so you are finding a sovereign function wali. Let us see how this finding has been given by the labor court on the basis of.
This has not even been dealt by the labor.
No.
That has been dealt with.
He only says that I am not a workman. It doesn't comment upon whether the respondent is an industry or not.
No. You see,
Oh, my lord.
ऐसा नहीं है. In the light of the law declared by the Supreme Court in Bangalore Water Board, education is an industry, but teachers are not workmen. So there can be industry, and within an industry there can be workers. Who stricto sensu are not workmen. What Mr. Sood is submitting is that within the panchayat, the work of tax collection is a sovereign function. Therefore, those who are involved in the sovereign function cannot be termed as workmen. इतनी एक contention. Let us see how the labor court का award पढ़ते हैं हम. फिर आएंगे दूसरे issue.
Page 7 से शुरू है.
हाँ, 9 से पढ़ते हैं. Para 9.
Parents, may I just tell you, the evidence has not been discussed in the award. That's one thing.
Evidence तो discuss करनी नहीं थी ना. इन्होंने सिर्फ ये देखना कि whether वो sovereign function अगर कर रहा है तो वो नहीं है. उसको
Before proceeding further, my lord, may I make a request? Whether the record of labor court has been summoned or not.
जरूरत नहीं है सर.
No, because your lordship, notices were issued and they have failed to bring anything on the record of the case.
Don't worry, let us see.
That they are workmen.
Let us see that. Yes.
Apex Court in case reported in so and so in case titled as Bangalore Water Supply and Sewerage Board versus Rajappa has found dominant nature tests among others for determining the nature of activity as industry. The dominant nature, where a complex of activities, some of which qualify for exemption, others not involves employees of the total undertaking. Some of
पंचायती राज एक्ट देना.
May I read the whole of this?
Please read.
Some of whom are not workmen, as in Delhi University case, or some departments are not productive of goods and services, if isolated. Even then, the predominant nature of the services and integrated nature of the departments, as explained in Nagpur Corporation case, will be the true test. The whole undertaking will be industry, although those who are not workmen by definition may not benefit by the statute. Notwithstanding the previous clauses, sovereign functions, strictly understood alone, qualify for exemption, not the welfare or activities or economic adventures undertaken by the government or statutory body. Even in departments discharging sovereign functions, if there are units which are industries and they are not substantially durable, then they can be considered to come within section 2G. Constitutional and competently enacted legislative provision may well be moved from the scope of that. These were the categories which were created. If we see, Lordship, what was the function which was being performed? The job for which we have been appointed. that was for collection of taxes with respect to a bus stand being operated by the panchayat. So it was a.
Let us see the power to collect tax under the Panchayati Raj.
So इसमें सिर्फ एक प्रावधान है जी पूरे एक्ट में.
Let us see that. बताओ.
This lordship would be power to contract for the collection of taxes and other dues. 17 होगा जी.
17. Okay.
Yes. This only says lordship a gram panchayat may, notwithstanding any law to the contrary, in respect of any area within its jurisdiction, enter into contract with the government or a local body to collect land revenue or any tax or dues payable to the government or a local body on being allowed such collection charges as may be prescribed.
No. This is, you see, this is how the tax will be collected. What tax can be collected by the? देखना पड़ेगा. पता क्यों? You see, there is law to the effect that everything which is termed as a tax per se is not tax. वो भी law है. So assuming इनको power दी हुई है tax की, लेकिन ये कुछ और collect कर रहे हैं in the name of tax, then it will not become tax. So अगर benefit of doubt इनको दिया भी जाए कि collection of taxation is a sovereign function, it will be confined to those areas or arenas only for which there is an express sanction in the act itself. वो देखो कहाँ
Act, sir, I have read the whole act.
पढ़ते हैं एक बार. मेरे हिसाब से कहीं ना कहीं कुछ है सर. ऐसा तो नहीं है ना? Without any authority, how can they collect the tax?
If we see the whole scheme of the act, lordship, there's not even a single provision where it may say that this particular tax can be collected.
नहीं, कुछ ना कुछ तो होगा इसमें.
My lord, it is, if it will help. Tax includes cess duty, free, rate or toll leviable under this act. Definition was 44, my lord. May see definition 44.
इसको 2 बजे देखते हैं. थोड़ा सा पढ़ो. पाओ. हाँ.
जब इनको डिमांड नोटिस सर्व किया ना जी, उसका इन्होंने रिप्लाई दिया. उस रिप्लाई में इन्होंने कैटेगोरिकली ये बोला कि हमने पार्किंग फी कलेक्ट करने के लिए गाड़ियों की इनको एंगेज किया. Perhaps that would be found in the records of the.
Mr. Sood, assuming, you see, tax and you see, let us. मैं वैसे बोल रहा हूँ तुक्के में. Let us take a case that there is a vacant area. और vacant area में गाड़ियां खड़े करने का ये 10-10 रुपए लेते थे. और उसकी कलेक्शन के लिए इनको रखा हुआ था. That is not tax. That is not tax. Tax is something else. Tax is 100 रुपए का बिल है, 2% GST, 2%.
That may fall within the definition of cess, my lord.
देखना पड़ेगा सर.
My lord,
I doubt.
no, my lord, we will assist this court on each and every point.
क्योंकि वो ये थोड़ा सा.
We will assist this court on each and every one.
Maybe it is relatable to बेचारे जो इनको नौकरियों से चले गए हैं, but it is otherwise of importance.
No, my lord, we will assist this court on each and every.
रिकॉर्ड आया कि नहीं? रिकॉर्ड आ गया देखो. रिकॉर्ड आया तो 2 बजे देखते हैं. इसको नहीं आया तो फिर मंगा देते हैं.
My lord, what I am submitting, if statute specifically says there is a provision in the Panchayati Raj Act, if my lord will have Rule 137 of the Panchayati Raj Act, remedies provided to them if a person has been wrongly retrenched or has been removed from the services,
appeal lies to district panchayat officer. That remedy is provided in the rules 137 may very kindly be seen. And of record is here. So अगर आप तैयार हैं तो 2
My lord, we have to inspect the record first.
Okay, इसमें लिखा when the case was taken on consideration and counsel for the party submit that they may be granted some time to inspect the record of the learned label. Based on dash to label the 23 जून अच्छा पॉइंट है इस पे देखते हैं अगर बनता है
Otherwise, specific remedy.
सेस और टैक्स की मेरे को वो लेकर आने लेकर आओ
सॉवरेन फंक्शन में क्या फॉल करेगा
सॉवरेन में यू सी पार्किंग के फी कलेक्ट करना तो सॉवरेन फंक्शन है मैं तो बट आपको एक्ट में थोड़ा सा देखना पड़ेगा कहीं ना कहीं कुछ होना चाहिए राजकुमार ये कैसे ये फेलिंग फुलिंग वाले हैं मिस्टर शर्मा आफ्टर 2 वीक देखते हैं रोस्टर रहता तो
नहीं तो ये तो हमारे को परमिशन दे दी थी वो फिर प्रिंसिपल ने परमिशन दी DFO said that no there are cases pending now those use case
बाद में देखते हैं if I do not have the roster
आपने रिकॉर्ड में आया था रिकॉर्ड मेरे को देखना होगा रिकॉर्ड में देख दिया have you taken sir my all affidavits are there in the record
ठीक है 23 को देख लेंगे ऐसे मेरे पास रोस्टर होता है ये अप्लाई कब किया हुआ था ये वो वाला केस अप्लाई बीट कब अप्लाई
प्रोडक्शन
yes please Hindustan Foods Limited yes reply filed
Rejoined also. They have filed an application for vacation of stay.
Mr. Balram
Yes, sir.
we'll take it up for consideration after vacation
As my lord.
okay you want इसमें लिखना you file a reply there too please.
So we have filed a rejoinder.
No. Have you filed a reply to the application
For vacation of
I'll
stay.
adopt the same rejoinder. I had said.
just file a formal reply
I'll file a formal.
notice accepts notice reply there too before the next date of hearing this Tom when do you want it
Push back at any time.
Immediately after vacation.
24th June
I'm there. 24th. I'm there.
interim to continue yes sir ये सूरज चौहान आया इसमें रिकॉर्ड एफसी का आइए इसमें when was the how to decipher कि आपने ऑर्डर कन्वे कैसे किया है इसमें ये कैसे पता चलेगा कि आपने वकील को जो भेजा था ना सर ऑर्डर कैसे भेजा था
पीछे लगो मैं
हाँ इनको बोलो
निकाल के देते
जस्ट वन Garja Ram. इसमें लिखना आपने learned additional general has produced the record of the case. Perusal thereof demonstrates that the arguments in the matter were heard on 18/5/2023, camp at Bilaspur, on which date the order was dissolved. Thereafter, the order was announced on 9/8/2023. However, in order dated 18th of May 2023, the date of order was not mentioned. Further, as per Jimny order dated 9th of August 2023, it was ordered that as the matter was reserved on 18/5/2023, therefore, the order be communicated to the learned counsel for the parties through counsel. Therefore, as it is evident that the petitioner was not having any specific knowledge of the announcement of the judgment on law, those are things, and he became aware of the judgment only after the order was received. Notice is being issued subject to the right of the private respondents on delays and letters. ठीक है? Return for dash types of the report stands returned. Yes, yes.
Can you pray for 30th instead of 24th?
Yes, please. Shri Ajay Sharma. ये क्या है सर? Pardon? अच्छा.
प्रोविजन करने वाला है।
बोलो 2 बजे आ जाओ सर, इनको बोलो लड़कों को 2 PM। नहीं ये दोनों, ये वही वाला है ना, गेट वाला 2 PM से। हाँ जी सर, कोई बात नहीं। क्या कहते हैं आप?
जी अच्छी पानी है। हाँ जी
आप भी ठीक है? हाँ जी ठीक है। Then I'll appoint someone. I'll fix his fee at 60,000 including expenses 20. With the observation कि जो हारेगा फिर उस आप
ये कम कर दीजिए, इतना कम कर दीजिए। पार्टी तो कीपर है जी, इतना नहीं दे पाए। पार्टी गरीब है जी, इतना नहीं है जी। हम
बंदे ने भी तो जाना है।
तो कम कर दीजिए, इतना हो जाएगा जी, इतना नहीं दे पाएंगे जी।
अभी सारा देना पड़ना, उसके बाद आपको तो सोचो।
नहीं वो तो
अभी तो जिंदगी भर यूज करना है।
ये कम कर दे।
नहीं रास्ते समझ नहीं खुद वहां देने वाले को खुद देखेंगे जाके
इंक्लूडिंग एक्सपेंसेस होगा। इसमें ऐसे लिखना, लिखिए दो ऑर्डर 110 की एप्लीकेशन है जो अलाउ कर देना, ठीक है? अमेंडेड by way of this petition, the petitioner has approached the court alleging that respondent number 4 has
actually granted permission to put the gates. After some days, he said that
has arbitrarily directed the petitioner to remove an iron gate, which was placed by the petitioner on the post permission granted by respondent number 4, though on a government land but behind his property, to check nuisance. ठीक है? Learned counsel for the private respondents, on the other hand, submit that the gate was rightly removed for the reason that by placing the gate, the petitioner was causing obstruction to the public path. ठीक है? Public path. To counter this, learned senior counsel for the petitioner stated that there is no public path per se, and there is no public path per se on the spot, though revenue records state so, and the area is being used by people to attend call of the nature, etc., and also for throwing garbage, etc. But local commissioner point कर रहा हूँ धीरज विशिष्ट
हाँ जी, हाँ जी।
इनके खर्चे पे आपका नहीं होगा इनके खर्चे। In order to assess this fact as to whether there is merit in the contention of the petitioner or that of the private respondents, as agreed, Shri Dheeraj Rishish learned counsel, who is present in the court, is hereby appointed. Is here today?
Yes, sir. Yes, sir.
He is appointed as the court commissioner, who shall inspect the spot in the presence of the parties, as also the SDM concerned and the executive officer of Municipal Council Kangra. At this stage, on the request of learned Additional Advocate General Sub-Division Magistrate Kangra is hereby implicated as respondent number so and so. पहले private आएंगे ना सर, उसके बाद ये लगा देंगे, है ना? Learned Commissioner shall file a report specifying therein as to whether there actually is a path which is being used by general public per se or not, or whether the vacant piece of land is being used for other purposes as alleged by the petitioner. The fee of the learned local commissioner is assessed at rupees 60,000. 20,000 shall be paid by the petitioner and 20,000 each by the private respondents. This shall be inclusive of all expenses. The bonus of the issue as to which party ultimately shall bear the fee of the court commissioner shall be gone into by the court later on. ठीक है जी?
एक और general public has necessity going to use this power.
वो मैं नहीं कहूँगा, necessity की नहीं बात है।
मैं बोले वो जो वहाँ जगह ही नहीं है दोनों टाइप।
कोई बात नहीं। List on 30th of June 2025. Registered to make available the record of the case to the local police shall render all necessary assistance to the learned commissioner to execute. चलिए
अच्छा ऑर्डर हो गया, ये धीरज का बर्थडे भी है ना।
This to the ये 2 बजे देख 2 PM. Rest of the cases are 2 PM. देखा मैम मिला? हाँ।
I've got that judgment also that was applicable to MBA and my case is undergraduate.
No,
I've got
undergraduation में देखो क्या है?
हाँ जी, इसमें मैंने देख लिया जी।
कितना है टाइम?
इसमें it is 6 years. 6 years.
That is why what I pointed to.
Maximum period is 6 years. I'm
Just 2 PM.
यार इसको बड़ी 2 बजे बार आई और
मैंने बोला लंच
ये इसको फिर कर देना, कर दिया ना ठीक। इसमें ये है, इसका फर्स्ट ऑर्डिनेंस है, ये है ना। ऑर्डिनेंस 10.33 ऑफ द फर्स्ट, आपके पास है मिला?
10.33 is strictly applicable to the MBA course.
नहीं नहीं नहीं, MBA courses जो maximum period is 6 years. You see, MBA course is only of 4 semesters. This is for such like courses also जहाँ पे maximum है 6 years का.
Page number 1158.27 also see.
इसके 10.33 है.
That was the CWP 4779, Mohit Shukla HPUC for decided by matter.
Okay, the MBA का है 6 years. Sorry, you are right. Huh?
I am covered by point number 8.8.
8.8. Let us see that.
Page number 107.
107.
That provides for 6 years for DA.
107 ma'am.
Please, sir.
8.7 point कौन सा?
8.8 Raju.
A candidate failing only in one subject will be given.
Last time.
Okay, candidate failing.
Admission to
Yes, sir. What do you say? बुला लो महाराज. कड़ा बेसब्री से इंतजार होता है. Yes, please, Naresh Sharma. Yes, please. Yes. Yes, what do you say? Huh? We'll have it also. Okay. Adjournment prayed for this on Tuesday. Yes, please. What do you say? So, are you indulging in the activities?
We were protesting,
No.
but we were in peaceful protest.
No.
No FIR, even they filed a complaint before the police station report is working, but no FIR was registered against us. I'm not denying this fact that we were
No, no.
protesting.
No one is saying that. The High Court has passed some interim order. है ना? In terms of that order, you have been restrained from entering within the radius of 500 meters of the project or any of the component, and you shall have no right to obstruct ingress or outgress, and shall not indulge in any violence, etc.
After this order is passed by order, we closed our immediate after we received this. Received this. Immediate after.
ठीक है.
Because the house of respondent number 7 and 10
is situated within the radius of 300 meters of power project.
You see, I'm going to dispose of this petition by making this order final. But I am ये जो restraint from entering within a radius of 100 meters, 500 meters है ना, इसको I'm reducing to 100 meters, 100 मीटर, है ना? वो उसके 100 मीटर के दायरे में नहीं आएंगे, बाकी जो मर्जी आप करेंगे. हाँ 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 हाँ, please do.
What had happened on 4th of February 2022,
हाँ.
NOC was given from Gram Panchayat was to the company roads.
Who are the respondents herein? Respondents हैं कौन वैसे ये?
Respondents ये पहले काम करते थे यहाँ.
हाँ.
Why this person's lordship mainly is leading the dispatch. And they are making.
But I'm praying for only 3 days.
Just 1 minute, just 1 minute.
And one is Pradhan.
Pradhan of?
Pradhan of Jila Parishad.
How is the, you see, how is, writ is not maintainable against private individuals. Those who have got nothing to do with the project. उनके खिलाफ आप civil court में आओ. This protection, just 1 minute. This protection is only vis-a-vis those persons who at one time might be your employees. बाकियों के लिए नहीं है. तो जाके फिर civil court में लेते रहो injunction उनके खिलाफ. हाँ. Without liberty. कहाँ है वो? Show me. Where is the averment made in the writ petition? Huh? No, show me the writ petition. When was this writ petition drafted?
चौबीस तीन को भी.
Just 1 minute. Huh?
Please.
First application. In fact, honestly speaking, the writ petition was not maintainable as on the day when you filed it.
Lordship, then we put the time and then we withdraw the.
Only then the notice was issued.
Please, Lordship. After that, the notice was issued. We took the time and then we draw the civil suit. Thereafter, the notice was issued by this honorable court.
But as far as these Pradhan etc. are concerned, show me, okay, which is the order in terms whereof you withdraw the case. Please show me that.
This is the order, Lordship, 29th March, Lordship.
Please read it.
Lordship, President so and so, the London Council for stated that in writing that he wants to withdraw the President's case with the liberty to file a fresh along with tagged CMA, and the London Council for the defendant has marked his no objection on the statement itself. Consider and allow. As such, the present case, along with the tagged CMA, is dismissed as withdrawn, and liberty of the file afresh in given plaintiff.
Sir, in the issues, you sought liberty to file a fresh suit, not a writ petition. You will file it. Then the petition is not maintainable. You should have withdrawn it with liberty to file a writ petition. Then it is not maintainable. Otherwise, also speaking for myself, I am not entertaining any writ petition against the residents of the villages. Agar koi grievance hai, go to the civil courts, seek injunction from the civil courts. But in the light of the order that has been obtained by you from the learned civil judge, you will have to approach him again.
Lordship, then I will have the instruction, Lordship, from the.
I am not blaming you, but the learned counsel who represented you, he should have been aware as to what he was praying before the learned court.
Maybe take it next week.
This message has put in appearance on behalf of the respondents. The court was apprised of the order passed by the learned civil judge Chamba in the civil suit filed by the petitioner dated 29/3/2025. A perusal of this order demonstrates that the pending civil suit along with the miscellaneous application was withdrawn by the petitioner with liberty to file a fresh suit. In the light of this fact, this court has its serious doubts as to whether the present writ petition is maintainable. And more so, this court is also of the considered view that in the present case, as there are persons other than the erstwhile employees of the respondent project who have been added as respondents, the courts open for the petitioner. Otherwise, just to approach the civil court to enable learned counsel to have instruction Monday.
I'll file power of attorney within 2 days.
Okay.
Let me.
Hearing matter. Yes, please, Balram Sharma. Okay, sir. ठीक है sir. This is Union of India.
Yes. These are two petitions, my lords.
What is the issue in this case?
The issue is that there is a award passed in 2017.
Okay.
We have filed an application for adjournment in this case, Lordship, that we intend to bring few facts before this honorable court, Lordship, why we are filing.
है क्या केस क्या है ये?
Lordship, we have challenged the award passed by the collector, Lordship, and initially we filed the reference also, Lordship. Then we filed appeal, Lordship.
Stay है कुछ आपकी stay वगैरह है कुछ?
Amount stands released in their favor also.
This has been hanging fire since 2020. Now they are saying that they want to give a better explanation why their reference was pending, and during the pendency of the reference they filed a writ petition challenging the award of 2017 and 2020.
मैं इसमें order करता हूँ list in due course. Why should we?
Only thing is that the connected matter which is tagged with this matter is the matter where I am asking for interest in delay of grant.
Dealing that will be heard and it will go into oblivion.
Can we have it?
Cost दे दो. सरकार को दो cost हुई.
इस बार भी थोड़ा सा
सरकार को थोड़ा
operational reasons है, Lordship. Operational reasons है. ये Air Force का center है जी वहाँ.
Then what?
Lordship, that
yes, Lordship. Date तो फिर
genuine reason.
In fact, my lords, just to appraise my lords, my petition was listed before the Honorable Chief Justice at one occasion, and the Honorable Chief Justice at that time, that bench was inclined to award me interest, because primarily it is a case where the award is passed in 17 and the disbursement is being made late, so Act itself provides for payment of interest.
Last opportunity दे रहा हूँ दो के बाद नहीं दूंगा, because you cannot become, you see, challenges to the award.
Yes, sir.
We have to see the veracity of the award on the basis of the material before the person who has written the award.
Yes, sir.
अब आप explain क्या करोगे?
Delay, Lordship, that there is a delay in 3 years approaching this honorable court.
When was the award announced?
Yes, Lordship.
Award कब का है, sir?
17, my lords.
And when did they approach the court?
2020.
So we just want to explain the delay, Lordship.
In fact, my lords, though it is people of India, my lords,
in case
a private petitioner, he would have been taken at task, my lords, that when the reference is
no, not even, no, even as far as Union of India is concerned, that judgment of the Honorable Supreme Court in Postmaster Journal, and that Perulal, if I am not mistaken, that state of Madhya Pradesh. Now the Honorable Supreme Court has used the expression that it is not a place where the courts are not place where the state can walk in any time. And the Honorable Supreme Court has gone to the extent of saying कि अगर आपको ऐसे ही लगता है तो please amend the Limitation Act. अपने लिए और बना लो provisions. But till the time these provisions are there, you have to adhere to them.
Yes, Lordship. So we'll, yes, Lordship.
So he is requesting that list after some time. Parliament का session के बाद रखो कहते हैं इसके इनकी request पे जुलाई की date दे देना. ठीक है?
I'm with
Delhi Journal of India pays for an adjournment. List on dash.
any specific date.
First, second, next case.
I'm with you.
7th July. Yes, please, Sohail Khan. Sanjeev Bhushan. ये क्या है सर? What is the issue? ये सर्वाइव भी करती है पिटीशन में?
गवर्नमेंट का था जी बाकी पब्लिक नॉइसेस एक्ट में Sovereign lordship, they're claiming shops on the ground floor lordship. We have already allotted them lordship, 3 shops lordship.
Protection order तो कि इनकी they will not be ejected from the premises.
So the Khoka have constructed their Khoka on the government land. And we have allotted them shops also. खोकर मूव कर रहे हैं और लीज की मनी भी पूरी नहीं दी है।
इन्होंने अभी तक ऑक्यूपाई किया कि नहीं किया ऑक्यूपाई? Because it appears that on the strength of the interim order, they are still continuing. Yes, Mr. Swain. Adjournment नहीं sir. You are enjoying an interim since कब से चला हुआ है? What is the issue? What is your position today? They have allotted you 3 shops जो इससे आई है, draw of lot से आई हुई है. Occupy them. No, sorry. तो क्या हो गया? This is code number 3. हाँ? No, you see, मैं वरना interim वगैरह कर देता हूँ फिर करते ना हमने. Because it appears that you still are occupying that khoka for the last 15 years now, and it suits you that the petition is lingered on.
इन दुकानें दे दी हुई हैं।
उनको ऑक्यूपाई कर लो जो है कल के लिए। इसमें मैं कल रख रहा हूँ, इसमें लिखना ऑन द रिक्वेस्ट ऑफ मिस्टर सुहेल लिस्ट टुमारो, बट आई विल डिसाइड इट टुमारो, कल के लिए। इसमें इशू ज्यादा लंबा चौड़ा है नहीं, इसलिए नहीं। अमिता चंदेल, यस कुठल, इसमें क्या इशू है सर?
Case of CWP order 2366 of 2019, Lordship. Lordship, in this year obtains the order. Thereafter, the management was taken over in the Hindu Religious Government Act. There is no stay granted over there. They were asked to plead the parties. Just 1 minute. And there is not listed today, Lordship. I submit they both will be taken together. CWP 2366 of 2019.
CWP 2366 of
2019. There they were asked to plead parties.
We have these cases after vacation. We will list it.
Lordship, it can be, but my friend Lordship is not.
Rando Sath, Mr. Kuthyala, there are 50. There are today 100 cases.
Lordship.
They are not connected with each other.
Lordship, the same property. I submit they both meeting for this reason, Lordship.
Your request has been acceded to, sir.
हमने कुछ नहीं बोला जी।
I'm only submitting both will be taken together, Lordship.
Now, Lordship, in fact, there's another application also. But my friend wants to file the reply, he may. Otherwise, on that.
देख लेंगे. List along with ऐसे लिखना. ऐसे लिखना list along with so and so SP.
And Lordship, there are 2 applications. Case he wants to file the reply.
जो भी है.
I'll file that. If need be, I'll file it.
Meanwhile, pleadings vis-a-vis petition stroke CNPs, if any, be completed. ठीक है sir? Next.
No date.
Right. Yes, please.
Your Lordship, in this state has filed the compliance affidavit. The freight charges, as per them, they have accepted the same.
Who are you?
I am a corporation, Food Civil Supply Corporation.
In view of the affidavit filed.
Yes, Sanjay.
My lord, can you
Just 1 minute. Yes, yes.
in view of the affidavit filed on 25th of May, Lordship, can be disclosed.
He's not here. Have you gone through the affidavit, ma'am?
Yes, sir, Lordship.
Does it serve your purpose?
Lordship,
हाँ? आप पूछोगे उनसे?
Lordship, उन्होंने agent करने को-
कब के लिए आना? कब आना उन्होंने?
After-
No, weekly, Monday. He'll be here on Monday. आप पूछो अभी फोन करके पूछो.
Yes, sir.
पास होगा. Mr. Sanjeev, आपका जो शॉप अलॉटमेंट वाला मैंने कल रखा, उसमें बंद उस एक कह रहे हैं कि हमने आपको 3 शॉप्स अलॉट की हुई हैं, लेते क्यों नहीं आप?
Well, the only thing is, जो जब जिससे चला हुआ है शुरू से, टाइम एंड अगेन दे हैव बीन टोल्ड एक तरह के पंचर लगाने वाला है, जिसकी होती पैसे उससे भी देंगे 25% और बाकी
तो 3 दुकानें थोड़ी मिल रही पंचर वाले।
नहीं, एक बाकी तो मैं वो तुम्हें बता रहा हूँ, उस पंचर वाले को ये देगा फर्स्ट फ्लोर
शुक्र बनाओ,
फर्स्ट फ्लोर में पंचर कैसे आया?
यही तो हिंदुस्तान का कमाल
या वही है अगर ऐसा हो सकता है।
3 शॉप्स दी हुई है ना सर?
नहीं 3 नहीं, वो 3 एक्चुअली 2 पिछले हैं जी, 2
वो नहीं है, एक ही है, दिखाओ।
नहीं 2 है जी, 2 है।
नहीं जो इस बंदे को 3 रिप्लाई
नहीं बंदे को नहीं जी, शॉप एक ही है सबको, 3 नहीं है जी। हाँ, और उसमें ये था शुरू से ही कि आप कैसे करेंगे अलॉटमेंट, इसी भी तो हुआ।
वो कह रहे हैं ड्रॉ फ्लॉट से आ गया हुआ है।
ड्रॉ फ्लॉट से उसके पहले ही था कि इन्होंने पहले 4 शॉप्स नीचे बिना ड्रॉ फ्लॉट्स के ग्राउंड फ्लोर पे दे दी। अब जैसे कुछ
वेयर डू यू अलेज दैट?
नहीं मैं अभी फाइनल आप
कल के लिए,
कल नहीं शुक्रवार रखने में बताऊंगा।
शुक्रवार,
हाँ, क्योंकि मैं सिर्फ बात ये है कि जो अगर मेरी पंचर की दुकान है,
तीनों पर एक चीज है ना, अगर तीनों की पंचर की दुकान है तो चलेगी, तो एक की भी
नहीं एक मैं 2 अलग है, मेरे को एक का जिसका याद था मैं बता रहा हूँ। अब पंचर वाला तो फर्स्ट फ्लोर पे नहीं जा सकता अगर कोई बुक अच्छी टेक्नोलॉजी है तो।
आजकल तो नाइट्रोजन डलती है ऊपर के,
नाइट्रोजन वाली की ज्यादा चलेगी जी, फिर मेरे को लगता है पहले वाली यूज की जो नाइट्रोजन गैस जो नाइट्रोजन भरेगा टायर में,
तो होती फर्स्ट फ्लोर में है।
नाइट्रोजन भी जो
ठंडा रखेगा टायर को ठंडा रखेगा।
और इसीलिए कोर्ट ने शुरू से बोला इनको
1500 काफी हो गया।
बीच के ऑर्डर भी बताए इनको जी कि भी आप इनको दे दो, और इन्होंने एक जगह में सजेस्ट किया हम तो पैसे दे रहे हैं, बगैर पैसे तो नहीं ले रहे।
That is something which may be beyond, या आप इनको अप्रोच करते रहना, विल डायरेक्ट देम टू सिंपैथेटिकली कंसीडर देयर।
इसको
इनको एक्सचेंज कर लो किसी के साथ।
हम तो शुरू से बोल रहे हैं कि आपने
किसी के साथ कर लो, जिसने
आपने जो 6 दिए हैं, जो नीचे 6 दिए
काय को मान लेंगे, आप तो खुद करो ना ये। व्हाई शुड दे,
हम तो फिर
they can't become your advocates, you will have to उनके साथ मिल जाए।
वो तो होते होगे कि 15 साल अगर वो डिसमिसल ही होनी तो फिर डिसमिसल ही होनी है। मैं तो ये बोल रहा हूँ
पता है ना, इसका पोजीशन पता क्या है? पोजीशन ये है, एज पर द रिप्लाई, इन लोगों ने दे हैव कंस्ट्रक्टेड अनऑथराइज्ड खोखास। ये बंदा उसमें अपना रोजी रोटी चला रहा है 15 साल से, ठीक है ना सर? अनऑथराइज्ड खोखा जो है, यू आर कंटिन्यू टू बी इन पोजेशन बाय वर्च्यू ऑफ अ कोर्ट ऑर्डर सिंस 2013। वो कब तक चलेगा? परपेचुटी में नहीं चल सकता।
हमने बीच में कोर्ट के वो ऑर्डर भी दिखाऊंगा जब कोर्ट ने बोला कि देखो क्योंकि इनके तीनों के बिजनेसेस ऐसे हैं जो फर्स्ट फ्लोर पे नहीं चल सकते, क्योंकि फर्स्ट फ्लोर पे नहीं चल सकते। हमने बताया भी कि पीछे जगह है, अच्छा एक दूसरा जो मतलब हर एक उसमें हमारे को बना के
परसों देखते हैं।
हाँ, हमारे को बना के दे दो, हम पैसे
आप खुद बढ़ाओ उसमें। चलो नो ऑब्जर्वेशन,
नहीं
नो ऑब्जर्वेशन,
हमने इनको पैसे देने, हम खुद बना लेंगे। बात तो एक ही,
नो ऑब्जर्वेशन। पता चले मिस्टर भूषण इज हैविंग अ प्रेस कॉन्फ्रेंस, नो ऑब्जर्वेशन। नेक्स्ट केस जोगिंदर सिंह,
ऐसा ना माय लॉर्ड।
नेक्स्ट केस
कब के लिए?
माय लॉर्ड आल्सो नो।
नेक्स्ट केस
एनी
तक आप देखो, you see only thing is
any
it will not be you see, assuming this is the situation, if you can work out the modalities with someone who is on the lower side, do it।
नहीं हम अपने आप कैसे कर लेंगे जी?
मान लेंगे
बनाए किन्होंने, बनाए इन्होंने जी।
and the problem is if you come to the court in 2013, petition is pending till since 13
they have been given opportunity time and again, resolve it। order दिखाऊंगा मैं, order हुए। अगर इनमें विल नहीं है, ये नहीं करना चाहते, और अब अपने जो गलत काम है इन्होंने क्या किया, 6 दुकानें अपनी मर्जी से नीचे दे दी बगैर ड्रॉप लॉट के। एक्चुअली नहीं तो उनमें से
none of them is the party here।
नहीं none of them नहीं, हम तो इस राइट पे आए, हम उनसे भी कैसे लड़ सकते हैं? हम है आपने जो दुकानें बढ़ाई, हमने भी आपको मार्जिन मनी दी, हमने पैसे दिए, लेकिन आप हमारे को फर्स्ट फ्लोर पे दे दोगे, वो तो कोई नहीं हुआ।
आप इंस्ट्रक्शंस दे लो, इस टाइम मैं ऑर्डर में नहीं लिख रहा हूँ, इंस्ट्रक्शंस दे लो।
आप बताओ कि
अगर इनका धंधा ऐसा है जैसे टायर वगैरह वाले हैं, तो इट इज प्रैक्टिकली इम्पॉसिबल।
हमारा केस ये शुरू से जी
प्रैक्टिकली इम्पॉसिबल to rehabilitate some that
as per the reply lordship they said कि नई बिल्डिंग तो बनाएंगे नहीं जी, वो
तो पता कर लो ना, कुछ हो सकता नहीं है तो भी कोर्ट इज नॉट फोर्सिंग यू, जस्ट हैव dispassionately have instruction।
yes, हम ये बोल रहे हैं, ये भी तो आप ही ने बनाई थी, ये भी किसी को पता नहीं था।
ड्रॉ लॉट पे आपको 3 दुकानें दे दी, 17-2200।
मैंने बोला हम फिर बोल रहे हैं कि ड्रॉ लॉट्स पे अगर आप पंचर लगाने वाले को फर्स्ट फ्लोर दोगे, वो तो वैसे कोई नहीं
इंस्ट्रक्शन ले लेते हैं।
इतने में तो अगर उसने वकालत भी कर ली होती ना, तो 12 साल की वकालत हो जाती थी आज को, और ऊपर ऑफिस मिल गया था उसका। 3 साल लग रहे थे लॉ करने में, 12 साल की प्रैक्टिस हो जा रही थी।
नहीं, ये 3 साल नहीं लगे।
क्यों?
पहले उससे पहले 15 साल तक ग्रेजुएशन करनी पड़ी।
ये तो
वो होनी नहीं थी।
ग्रेजुएट हो
ग्रेजुएट नहीं है जी, तो ग्रेजुएट होता तो पंचनामा लगा रहा होता।
यस यस मिस्टर महाजन।
The award of the Liverpool Malone will be 54 days, not 97 and 98.
फिर
They look into the same and pass it up.
बच्चों को पता नहीं ना, हमारे टाइम आता था डालडा घी, so D for
Malone, but can I argue on this because Malone is only he has put in 54 days.
don't worry, इसमें ऐसे लिखना by way of this repetition.
Malone, what happened? He came twice. Once Malone he raised the demand notice. It was sent. Malone paid their court. It was rejected. He did not receive in the High Court. Subsequently,
मैं उसी पे कर देता हूँ
7 years he again raised it, Malone, for the same issue, Malone. Then the Labour Court observation is, Malone, that for earlier it has become final. Subsequently, Malone, he has been able to show anything.
कोई बात नहीं, देखो सर, by way of this repetition, the petitioner has assailed the award passed by the learned Labour Court, Kangra Dharamshala, in reference number so and so, title so and so, dated so and so, in terms thereof, the claim of the petitioner was rejected by the learned Labour Court. Brief facts necessary for the interpretation of this petition are that in an industrial dispute raised by the petitioner, the following reference was made by the appropriate government to be answered by the learned Labour Court. The petitioner filed his claim before the learned Labour Court. Full stop. According to the petitioner, he was engaged as a baildar on daily wage basis by the respondent with effect from 26/12/97. Full stop. He continued as such till 25th of March 1998, when his services were terminated by violating the principle of last come first served. Full stop. He raised the industrial dispute in the month of April 2004. The appropriate government rejected the demand notice on 25th of August 2006. In 2012, when petitioner came to know that some workmen terminated before and after him were re-engaged, he again raised the demand notice on 8th of February 2013. The same was again rejected by the appropriate government. The petitioner approached the High Court and the writ filed by the petitioner was allowed, and a direction was issued to the appropriate government to refer the matter to the court for adjudication.
And this reference was made.
Thereafter, the reference was made by the appropriate government. According to the petitioner, the discontinuation of his service was in violation of the provisions of Section 25G and 25H of the Industrial Dispute Act. The respondent resisted the claim of the petitioner and inter alia took the stand that he had not completed more than 240 days in the preceding 12 calendar months as from the date of the termination of the service, nor any person junior to him was retained, neither any fresh hand was engaged there. Learned tribunal framed the following issues on the basis of the pleadings of the parties, and the same were thereafter answered as well. Learned tribunal, while deciding issue number 1, held that in terms of the mandate chart, the petitioner had worked for only 52 days. Thereafter, he approached the appropriate government second time after 13 years, and this long delay in itself was sufficient to deny the right to claim compensation, more so taking into consideration the fact that he had only worked for 52 days in 2 years. Primarily on these reasons, the claim of the petitioner was rejected. Having heard learned counsel for the petitioner as well as दूसरी तरफ से कौन है?
Up to Delhi Union, I think up to कोई और है GHPSC भी कर.
इसमें लिख देना, none कर देना, ex party नहीं करना, none कर देना. Having heard Mr. Mahajan learned counsel for the petitioner and क्या लिखा आपने? नहीं ऐसे लिखना, learned counsel for the petitioner strenuously argued that the learned Labour Court erred in not appreciating that as the termination of the petitioner was per se bad, as it was violative of the provisions of Section 25G and 25H of the Act, and further as the High Court had directed the appropriate government to forward a reference, the rejection of the claim of the petitioner on the ground that the petitioner had had raised the claim belatedly is not sustainable in the exam. Accordingly, he has prayed that the petition be allowed and the termination of the petitioner be held to be valid with all consequential benefits. Having heard learned counsel for the petitioner and having perused the award under challenge, this court is of the considered view that in the peculiar facts of the case, the petitioner is not entitled for any relief from this court. It could not be disputed before this court that the petitioner had worked only for 52 days from 26/12/97 up to the date of the termination of his service, that is 26/3/98. That is terminate 26 को ही है 26/3/98. Therefore, but natural, petitioner had not completed more than 240 days in the preceding 12 months as from the date of his termination. In fact, he had not even worked for 12 months, as he had only worked for about 3 months with the respondent. It is also clearly borne out from the record that after the first demand notice of the petitioner was rejected in the year 2006, it was only in the year 2012 that a fresh demand was raised by the petitioner. This court is of the considered view that the findings returned by the learned labor court that after the rejection of the first demand notice, the petitioner stepped over his rights are correct finding, for the reason that there is no just and cogent explanation as to why no action was taken in this regard by the petitioner from 2006 up to 2012. The contention that this reference was raised when persons junior to the petitioner were re-engaged, etc., has not been substantiated before the learned labor court by the petitioner. Therefore, these barred assertions not having been proved, do not demonstrate that there was any violation of the provisions of section 25G and 25H by the respondents. In the light of above observations, otherwise also, as the findings returned by the learned labor court are clearly borne out from the record of the case, and further, as in the exercise of its power of judicial review, this court is not to sit as an appellate court and reappreciate the evidence. The present writ petition is dismissed by observing that there is no perversity in the findings returned by the learned labor. Yes, please.
Tuesday.
Please, from Tuesday. Ma'am, some praise that Mr. Jaswal is not available. Case be taken upon to order to call him this time. Yes, please. Please to leave. आए नहीं? हम बाहर ही बैठे हैं, गप्पे मार रहे हैं. हम बुलाना जरा. हाँ जी सर, what do you say? Your learned friend has said that as per 8.8, 6 years for graduation also, or first ordinance. So what do you say?
Then we were banking upon 5.1, 5.4.
5.1 क्या कहता है?
5.4 in fact, Lordship.
What does that say?
Merit list. Save as elsewhere provided. In examination in which a candidate has to appear to complete the degree of undergraduate class, the period between the examination that he/she passed before
and the next examination shall not exceed 3 years. And in case of a candidate of postgraduate class under semester, such period between one semester and another shall not exceed 2 years. Now, if your lordship may kindly have my reply in para 3 thereof of the preliminary submission objections.
तो इनका petitioner का कौन सा semester रहता है?
Second year.
When did you appear in the BA second year examination?
But I had to appear in the BA second year examination, but my form was not taken. That's why I filed. I appeared in BA first year in 2019.
2019. Just wait.
The exam for the same was held in April.
No, you see, in terms of 5.4, if you passed out your first year in 2019, then अगर 6 साल का ग्रेस भी है, आपको सेकंड ईयर का एग्जाम जो है वो 3 साल के अंदर अंदर देना था, वो आपको 22 से अंदर अंदर देना पड़ना। अगर आप 22 से पहले नहीं बैठेंगे तो फिर ये 6 साल का ग्रेस आपको नहीं मिलेगा। हाउ डू यू wriggle out of this?
I passed my BA first year in April 2020. Thereby, I applied for technical education. I did my.
That is immaterial. As per the provisions of the first ordinance, the gap between the last exam and the exam you are supposed to take cannot be more than 3 years. Yeah, na, sir? Cannot be more than 3 years.
But the relevant provision which he is reading is applicable to private students. The chapter deals with private students is chapter 5. And I am not a
private candidate.
I am not a private candidate. It is registration of chapter 5 deals with private students.
No. But now you will be appearing as a private student.
No, my lord.
No?
This is my. There are three categories in the university. One is a casual student, which has been defined in these rules also. One is a regular student.
Please,
and one is a.
नहीं, ऐसा नहीं है ना. Please read 5.2b. Please read it. 5.2b. 5.2 पढ़ो आप. The following category of candidates may be permitted to appear as a private candidate. Those regular students who fail in an examination, provided they take examination within 3 years. Those who fail to appear in any examination of university after having completed the course of instruction and having fulfilled the other requirements prescribed. Fact of the matter is, you see, you cannot be a regular member of a stream or of let us say you are doing law. ठीक है ना मैम? You have to complete law within 3 years. ठीक है? 3 years में अगर आपकी आप नहीं होती है और अगर आप 5वें साल बैठ रहे हैं, you cannot sit as a regular. I have my doubts. You will sit as a private candidate.
How the principal has allowed them? That was in fact that is why the.
There is another category. That is a casual student. Whereby I may kindly see annexure P1 is my I-card, which has been issued to me in August 2023 and which was valid up to 31st May 2025.
So let us see where is the definition of casual. Yeah. The principal chairman may allow a student who is eligible to as a private candidate. A casual candidate also has to fulfill the eligibility of a private candidate. You forget private or casual. Main hurdle जो है वो ये है that there cannot be a gap of more than 3 years in the last examination undertaken by a student and the next